Respected principal, sir, can we start the event?
Go ahead, madam.
Okay, thank you, sir. Mihir, you can continue.
Ma'am, am I audible?
Yes,
Yes,
sir.
yes.
A very good morning to one and all. Myself, Mihir Karnik, from BA LLB third year, welcome you all on behalf of Marathwada Legal and General Education Society, Manikchand Pahade Law College, Aurangabad. Today, on this auspicious occasion of World Human Rights Day, we are gathered here for the inaugural session of National Level Online Training Program on Child Rights, National and International Perspectives, organized by Avishkar Research Club in collaboration with Jean Monnet Module, Center for European Studies, and JNU, New Delhi. I now request Vice Principal More sir to kindly give a welcoming address. Over to you, sir.
Thank you, Mr. Mihir. I hope I am audible.
Yes, sir.
Yes, sir. Yes, sir.
Very good. Respected Principal Dr. C.M. Rao, sir, the President of this inaugural session, respected Dr. Sital Sharma, ma'am, and Coordinator Dr. N. Kotapalle, madam, all the participant, faculty, student who are participating in this event. At the beginning, I wish you all the best on the occasion of this Human Rights Day. And I congratulate all of you, including myself, for being a human being. We are going to celebrate this Human Rights Day. You know, human rights are very important for our survival as a human right. And we have availed this opportunity to celebrate this day. Today, we have with us Dr. Banerjee Chakka, Dean and Professor of Law, Professor Dr. Nirmala Madam, retired Professor of Law from Andhra University, and Dr. Sital Sharma, Associate Professor from JNU, New Delhi. Respected all, I am here to welcome you on behalf of my Marathwada Legal and General Education Societies, Manikchand Pahade Law College, Aurangabad. Dear friends, we are celebrating this occasion on the eve of every International Human Rights Day on 10th December. And I am happy to welcome you all in this August gathering this year also. I am also eager to hear you all, and without taking much time, I will conclude my welcome address here. Thank you very much.
Thank you, sir. I now request our IQAC coordinator, Dr. Aparna Kotapalle, ma'am, to kindly introduce the event in brief. Over to you, ma'am.
Thank you, Mihir. Good morning, everyone. Good morning, Sheetal Madam, respected Principal, Sir, Vice Principal, and all the dear participants. I feel very happy and privileged to communicate you the research club activities as well as while introducing this particular event. Our research club of the college was inaugurated in the year 2010-11, somewhere in the academic year. Since then till now, apart from training the students on the research activities, we are organizing many activities on Human Rights Day. due to which the students, faculty members, excuse me, echo का येत आहे. I feel sorry for the inconvenience that was caused to everyone due to the echo. Really pardon for that. The thing is that since last 10 years, I was telling you since the beginning of this research club till now, we have organized many activities apart from the training on research methodology and conducting certain research projects. Apart from that, every year we have celebrated Human Rights Day by organizing workshops, seminars, symposiums. Till now, I feel it essential to communicate it to you all that since beginning it was a right of women as human being, and the laws for implementation was the first from where we had started with. Then it was role of advocates in protecting human rights. Then role of police in protecting human rights, role of judiciary in protecting human rights. Each year we were dealing with some separate issues, different issues. One year we dealt with a farmer's suicide and aftermath kind of thing. That particular area we had chosen. Then right to water, right to shelter. In very recent past, in the previous year, we have organized international conference on human rights during COVID-19 pandemic. During which we also had invited for the research articles, and our college has published one book. And that was apart from the my mobile just chill. Apart from the workshop, it was a separate activity, and I'm happy for that. Now, apart from that, we are planning to go with certain projects at national level, wherein we would be discussing, rather we would be studying the environmental issues this year. Now, coming to introduction of this particular event, this event actually was germinated in the mind of our faculty that why not to conduct the training program on child rights, which has left untouched till now. So we had sent the proposal to Jean Monnet project under the leadership of Dr. Sheetal Sharma ma'am, and she was kind enough to grant the financial assistance and support also to us on this occasion for conducting this event very successfully. So let me thank her for first of all for her support, kind support and cooperation. This training program consists of 4 sessions apart from this inaugural and valedictory session. And as has been mentioned by our Vice Principal, Sir Sharma Madam is one of the resource person for today's training program. Apart from her, Dr. Chadda sir, Banerjee Chadda sir, Nirmala ma'am, and Dr. Asha Bajpayee ma'am, who is a retired professor of Tata Institute of Social Sciences, Mumbai. So with the discourse and the intellectual feast that everyone would be providing us during the training program, I hope along with all of us, even you people would be enjoying this intellectual feast. I'm happy that even Nirmala ma'am is there with us. Thank you, ma'am, for joining us for inaugural session 2.
Yeah.
And happy to communicate you all that almost 520 registrations have been done for this particular workshop training program. Most probably, it is too early for many of the participants starting by 8:30, but we could not help because we had to arrange the things in a proper time. So maybe within a short span of time, others will be joining soon. And I hope that everybody who has joined this training program would be certainly sensitized on the issue of child rights, and we would be extending our helping hand to the nation for protecting the rights of children. Once again, I wish you all the best on the eve of Human Rights Day, International Human Rights Day, and I thank the organizer for giving me the opportunity to express the activities of Research Club as well as introducing this particular event. Thank you, one and all. Over to you, Mihir.
Thank you so much, ma'am. I now request respected Dr. Sheetal Sharma, ma'am, Associate Professor of Law at JNU New Delhi, to kindly give an inaugural address. Over to you, ma'am.
Good morning and a very warm welcome to all of you. Honorable Dr. C.M. Rao sir, Principal MP Law College, Nirmala ma'am, we have More sir, Vice Principal, Dr. Aparna, dignitaries, panelists, and all my dear colleagues out there among the list of participants, which I see is now hitting 190. It's like a cricket score going up and up. And why I say warm, because in this side of the country, it's really, we are wearing winter clothing, you know, and I see so a warm environment there in Maharashtra that some of the fans are on. Now, it gives me immense pleasure to collaborate with MP Law College, number one. The reason is that, which I would also talk about later sometime in next months, or I will also request all my colleagues or professors to apply for some of the funding related to projects, which is, if you can recall the banner of this program, you will see that there is a small logo mentioned there, Jean Monnet module, co-funded by Erasmus Plus program of the European Union. Now, what is this logo for, and why Aparna ma'am very humbly said, you know, and this was too much, Aparna, to say that this collaboration was done in order to carry out one of the activity or event of a project that is awarded to me by the European Commission. And it is one of the projects in which we are mandated to carry out certain activities, academic events, in collaboration with other universities or college. Although, of course, you can always carry out these events standalone in your university or in your college, but I always intend to collaborate with my friends, with my colleagues all over India and as well as abroad, in order to enhance the visibility of the project and maximize the benefit to the scholars, researchers, students, and everybody whosoever is a stakeholder. Number two, why on Human Rights Day? Human rights is one of those concepts which is all encompassing in the sense that it's an umbrella concept which almost includes everything in this world, directly or indirectly. If I draw a concept map of rights, you can relate it to almost every place, even right to sit in a clean environment or right to breathe in a clean air. Absolutely essential from this up until what is constitutionally guaranteed to you or what are universal laws. Throughout the day, half day workshop, we have immense expertise which is going to speak on it. And I want to tell you one thing, I was called as an expert first and then as a sponsor, not the other way around, that I sponsored the program and then I was called as an expert. Thank you, Dr. Aparna. Thank you, Rao sir, for inviting me to be part of this this August gathering and this event. I'm looking forward to the ideas of other experts, those who are going to enlighten us about the various aspects of human rights. And yes, I wish the organizers and the team good luck to carry out this work, and we look forward to future collaborations in the similar fashion. Thank you so much.
Thank you, ma'am.
Thank you, ma'am. Thank you so much. I now request respected Principal Dr. C.M. Rao, sir, to kindly deliver the presidential address. Over to you, sir. Sir, your mic is not unmuted.
Stop echo. I stopped that. So, on behalf of the management, staff, and students, and our collaborating partner, and the student friends, it gives me immense pleasure to say a few words on this occasion. It is a decennial year of celebration of human rights in this college. Even though we are celebrating every year, all all human rights day is to be celebrated. From 2010 onwards, we have made a history beginning by establishing a research club by way of which our students get knowledge from various fields on which they can do research work. As a part of this research program, they have compilated on environmental law, they have compilated on right to privacy, they have compilated the particular subject relating to the contempt of court, criminal contempt, civil contempt, like that. Every year they are giving a team on which the students are advised to make a research and compile all the particular decisions on articles relating to the particular subject, not only for the benefit of the future generations, but also they will also have the knowledge of the subject. So everything is taught not in classrooms. The students should learn outside the class also. This is an activity which is initiated by Aparna, the IQAC coordinator, with a view to input into the mind of young budding lawyers, the research. As a lawyer, we don't know what type of case comes to us. Every time for every case, we have to make research. Unless you make a research, you cannot win the case. That is one important element for which we have started a research club. On this particular Human Rights Day, this particular child is considered to be the most vulnerable group where they are not be protected properly. When you look into the people who are in rural areas, there is only 20% of potable water, which is pure clean water that is available to the children. And because of this water deficiency, malnutrition, these are the things that they can't fight for their rights. And apart from the particular thing, there are other things which are going to be suffered by these exploitation by near and dear, sexual abuse. There are several factors which are influencing exploiting the young budding kids who are the future of our nation. As a legal fraternity, it is our responsibility to protect their rights and to keep them in the path for the future of this nation. And on behalf of the management and staff, I welcome all the dignitaries who are the resource persons, Banerjee Chakka, Nirmala Madam, Sital Madam, and also Bajpai Madam, for this wonderful mist where they are going to share their ideas, where they are sharing their expertise in the particular field to benefit our students and also the various faculty from various parts of India. There are several faculty members. I have seen the participants and attendees. There are several faculty members all over India. So I congratulate all the persons for taking keen interest in this program, and I wish the program a great success because of your participation and expertise knowledge shared by the guest friends. Thank you one and all.
Thank you, sir. I thank Dr. Sheetal Sharma ma'am for inaugurating this event. I also thank President, the Vice President, and the General Secretary of MLNGE Society for their constant support and encouragement. I also thank respected Principal Dr. C.M. Rao sir for the presidential address. I thank Vice Principal More sir for the welcoming address, and I also thank Dr. Aparna ma'am for the introduction of the event. Also, all the non-teaching and teaching staff who have given their contribution. I request all the attendees to kindly stay tuned with us. We will be beginning our first session very shortly.
Thank you, ma'am. Our resource person for the first session will be joining soon within a minute, I hope. He has communicated this particular progress to me. But till that time, we can utilize the time for getting the names from your side that who would be rather willing to give your feedback after the event is over. So most probably you all will be there for all the 4 sessions. And during the valedictory, we would be happy to know certain things from your side, not only in writing or the link that would be shared to you, which is a mandate. But apart from that, if anyone is interested giving feedback or overall expressions about this particular event which we are going to conduct for the day, please let us know. Okay, you can place it in the chat box, your names and designation, and we would be happy to listen to you. It would be helpful for us for the improvement or overall improvement and conduct of events in future. Thank you.
Aparna, in the meantime, can I add something about the Geomone activities also to keep the audience here?
Yes, ma'am. Yes, ma'am. Please.
Go ahead.
Okay. I would like to tell my colleagues about Geomone activities. And this is very simple. All of you are logged in right now. And later on, you can type Geomone, Jean. Jean. This is a French word, so it's pronounced as Jean. And Monet, Monet. Geomone activities. And if you type Geomone activities 2021, there will be a link which is Europa or Erasmus Plus activities. Kindly open that link, and in this set of activities you will get couple of areas in which you can apply. Those who are assistant professor and associate professor and you are doing something related to Europe, because European Union mandated to promote European studies in India or understanding about Europe. So directly or indirectly, if you tend to teach something which has a component of Europe, you can apply for a module which requires 40 hours of teaching, 40 hours of teaching in a year. So you get a maximum grant of 30,000 euros for 3 years. 30,000 euros means, if you roughly calculate it with 80 rupees per euro, which means 24 lakhs rupees, you get for 3 years to promote European studies in India. And if you are a full professor, then you can apply for a chair. A chair is for 50,000 euros for 3 years. So which means roughly uh, 40 lakhs of rupees. So this is the amount of the financial grant which is given to you. It's not that everybody gets 30,000 or 50,000. Depending upon number of hours that you teach, it can come down to 20,000 for a module or something like that. So you have to apply for it. Find out. I'll share with Aparna. Be in touch with Aparna ma'am and Principal Sir. I will share links with them from where you can get greater information or details of this information. And please try to fill this form. This is very good for your professional development, for your personal development, for your academic development, and otherwise also. Because if you fulfill these 3 compartments, professional, academic, and personal, then absolutely the spillover effect is upon every aspect of your life. And what do we do? How do we use this grant? Number 1, that we are teaching European studies. Number 2 is that, please let me know when the expert is joined. Number 2 is that you have to organize certain events
Sorry,
and
to join, but
yes, he is joined.
yes,
Yes, so
yes.
just finishing it.
Yes.
Events and activities which are related to academics and the theme of the project. So please apply for these grants.
Thank you, ma'am. Mihir, as our resource person for first session has joined, I would request you to continue with the first session.
Yes, ma'am. Thank you, ma'am. Once again, a very warm welcome to one and all to our first session. Our first session will be focusing on introduction to human rights. And now, to say a few words about the theme, I request Professor Suhas Narhari Turadmal sir, Principal in charge of C.D. Deshmukh Law College, Ahmednagar, to kindly take over. Over to you, sir.
Okay, good morning to all. Am I audible?
Yes, sir.
Good morning.
Yes, sir. Yes, sir.
Thanks to Aparna ma'am and college authority to given the opportunity on the provision of human rights on child rights. That is, all children deserve equality despite their difference. They are entitled to all these rights, no matter what race, colors, religion, language, ethnicity, gender, or abilities define them. So every child has a dream to pursue, give them rights, fundamental rights of children. Child rights go beyond just human rights, which exist to ensure fair and proper treatment of a people across the world and promote their well-being. So these rights encompasses freedom of children and their civil rights, family environment, necessary health care and welfare, education, leisure and cultural activities, special protection and measure. The rights to identity, that is, children are entitled to a name, legal register with the government and nationality, as a right to health, that is a medical care, nutrition, protection from harmful habits, safe working environment is necessary. The right to education, right to free education for helping children to develop discipline, life skills, healthy environment to measure a child psychological development, as well as the right to family life. Children must live with their parents. Right to be protected from violence, that is a sexual exploitation. Protection from violence extend even to family member children and must not suffer ill treatment or sexual or physical violence. Avoid rape of children, child prostitution and child pornography is necessary. The right as opinion, all children deserve the right to voice their opinion free of criticism and contempt. The right to be protected from armed conflict. That is, armed conflict converts innocent children into refugees, prisoner, or participant in armed conflict. This must be corrected in nurturing safe environment. Right to protected from exploitation, child labor, juvenile justice under no circumstances should be individual to be sentenced death penalty or juvenile life without parental pity. So our hopes are more just, safe and peaceful world can apply be achieved when there is universal respect for the children or inherited dignity and equal rights of all members of the human family. Thanks to Aparna ma'am and organizing committee. Thanks to over to me.
Thank you, sir. Thank you for that introduction. We are extremely
Yes.
delighted to have Dr. Banerjee Chakka sir with us today, Dean and Professor of Law at VIT AP University, as our resource person for this session. I would like to take this opportunity and say a few words about sir. Dr. Banerjee sir graduated with BA LLB from Andhra University. Sir completed his LLM from the University of London and his Masters in Philosophy and PhD in International Law from JNU, New Delhi. Sir also completed postgraduate certificate course in Teaching and Learning in Higher Education and postgraduate diploma in French Language, Literature and Culture from National University of Ireland, Galway. Sir was British Chevening Scholar at SOAS from 2015 to 16. Sir has worked as an Associate Professor of Law and Registrar at National Law University and Judicial Academy, Assam, lecturer of law, a lecturer at School of Law of National University of Ireland, and as a legal advisor to International Committee of Red Cross Regional Delegation for South Asia, New Delhi. Sir is also associated as a judge at several prestigious national and international level moot court competitions. Sir is also a recipient of a doctoral scholarship awarded by the Hague Academy of International Law. It is an honor and privilege to have you here with us today, sir. I would just like to add a small instructions for the attendees that if they have any questions, uh, please do leave them in the chat box, as after sir's address, we will be having a small Q&A session. So without any further ado, I now request Dr. Banerjee sir to kindly enlighten us. Over to you, sir.
Thank you very much and good morning, Mihir. And can you give me the share option to share my screen?
Yes, sir.
Yes, ma'am. Aparna, ma'am.
Yes, sir. Immediately I will be doing.
Yeah.
Please.
Yeah, thank you very much, ma'am. Indeed, it's a pleasure. And thank you so much to the Manikchand Pahad College of Aurangabad. Indeed, it's a pleasure for me to be part of this important occasion and the gathering. The important occasion is, as we all know, that we are celebrating International Human Rights, one of the prestigious events which is celebrated across the world. And also, I'm very thankful to the organizers, the college principal, Dr. Professor C. Manikyal Rao sir, and the coordinator, Dr. Aparna Kottapalli ma'am, and for giving me an opportunity to interact with each one of you and share some of my thoughts. And this morning, I am going to give you a brief introductory note on the human rights, a national and international perspective. I know that it is a very vast topic for a student of human rights law, but I try my best to give you that a kind of recap of all the things which are essential for our understanding of human rights, maybe within the allocated time. Okay. I can't put this into PowerPoint mode. The reason is that very simple, because sometimes due to network issues, slides may not change. So that is why I'll keep like this. And I hope this particular slides are visible to all of you. I presume that it is visible to all of you. And also, if you have any trouble, please just let me know. Thank you very much. So my dear friends, like every year we celebrate this International Human Rights Day. That is a commemoration of the adoption of Universal Declaration of Human Rights by the United Nations General Assembly. And this particular idea of human rights, when we are celebrating, it is a kind of reminding ourselves about the obligations of human rights law, which has given by the International Covenant to the state parties, particularly the parties, those who are signed, ratified the international covenants, as well as adopted the principles which are there in the Universal Declaration of Human Rights and also part of United Nations Charter. So if you look at that international human rights law principles, generally people from the different cultures, they perceive that, oh, the human rights are alien and they have this Western notions of rights, etc. But they are different from the different cultures. So that debate goes on to that cultural relativism. But in the midst of these debates, I would like to remind you and assess that the rights, and particularly the human rights, are embedded in the every culture and every civilizations, and they are as well as the history of the human civilization. And it is not an alien, and they are part of our cultures, the part of our societies, the part of our normative framework. Whatever the society you live in, the society must be adhered to the principles of international human rights law and the human rights which are there in our constitutions. So I recall the famous statement made by Mr. Kofi Annan, the Secretary General of the United Nations. They say that human rights are not alien. They are part of every culture and every civilization, and also they are part of the individual growth and human culture. You cannot just deviate by saying that they are from an alien culture it belongs to. So coming to that, the point which I would like to say in my presentation, that is my presentation primarily is in three parts. That is the basic introduction of the human rights, followed by the international perspectives, and then I come down to the national perspective. So I try to wind up within the stipulated time. So as I am trying to talk here, the history of humankind, if you look at that, the rights have been associated with the long struggles of individuals against the injustices and exploitations and disdains, because the rights have emerged basically from the aspects of injustices meted to the people and exploitation which were meted out to the people in all over the world. So if you recall the words of Justice V.R. Krishnaya, he says that ultimately humanity has to a commitment to the history to make human rights a viable reality. So if I recall just yesterday, one of the judges, I don't want to take the name, but the judges is clearly say that our progress is not measured by the building of roads, statutes, and other infrastructures, but our success is measured with the enshrining in and upholding the values of the constitutions and the rights which are there. So if you look at that the statement which made by the judge yesterday and the statement made by Justice V.R. Krishnaya, and if you relate these two particular statements, that clearly gives us a kind of an idea that they are ingrained into the human cultures. So my dear friends, that you have to look at it. So I just want to make an attempt to go back how this human rights have been come. So my main attempt is that to trace the entire cultures and origins and also different geographical regions, how these roots of the protection of the human rights have been traced. And if you look at that, the ancient civilizations, particularly Indian civilizations and the Babylonian laws and the Greek and Roman cultures, if you look at that, all these particular cultures and regions, they have human rights despite of the differences in their content. The content may be different, but the spirit of the human rights is the same. So these human rights are rooted in the ancient societies through the philosophical concept of the natural rights and the natural law principles. And these natural rights and natural law principles have to be perceived by the people based upon the reasoning and rationality. I stress that reasoning and rationality, not based upon the morals and the dogmatic beliefs of the religion. If you apply the dogmatic beliefs of the religion and morality to the rights of the natural law, rights of the human beings, then what happened? We are going to make injustices again. Hence, what I would like to say that these natural law principles and the rights which are embedded into it, the natural law, must be perceived by the people with the rationality and the realism. So if you look at that, the Greek philosophers, they have recognized the idea of the natural rights. Even if you look at the Roman jurists like Alpine, he says that natural law was that nature and the state assures to all human beings. If you look at that, the Roman and the Greek civilizations, they have the city-state systems and they assure, and the human beings must be respected and their dignity must be protected without compromising on their liberty. So this means the rights are not alien to any culture. And these rights, the natural rights which we call it, and they are also equally applicable to the aliens as well as the foreigners, and they must be treated in the same way as they deal with their own citizens, individuals, and their compatriots. This is very, very important, my dear friends, because the ongoing tussle which is going on across the world, where when the refugees are emerging from out of the conflict zones because of the perpetual threat to their life, now some of the countries, they are building walls against the principles of the customary principles of human rights law, which is recognized by the refugee law, that is non-refoulement. See, you have to deal these migrants or maybe migrant workers or the refugees. You have to treat them the way as you deal with the one's compatriots. So my dear friends, if I take this one into in the history of both India as well as in other cultures, we have when the threat of life was questioned, the life was given threat, and then they crossed the borders and they went to other places where they were given asylum. So that cannot be compromised. So that means in every culture, I am just trying to refer Lord Sri Krishna, when his mother gave birth to him in the prison, and because his uncle was about to kill all the children, and he was taken away and reached to the some other shore, and he was taken care of by the local people. So that says that it's a kind of compatriation. Compatriots must be treated alike. And even if you look at the Bible, the story of Bible goes like this. Many of you are aware of it. When Jesus was born, the King Herod was killing all the children below the age of 3. And what happened when they fled Bethlehem and went to Egypt, and they were given a status? The foreigners, they were treated in the same way as they dealt with the compatriots. So it is implies that international law must be there in all the cultures and all the religions, and even including the situations of conflicts or wars, and including the situations of the wars and conflicts. So the people have to be treated more humanely by the state as well as the adverse parties. That's why we call it as international humanitarian law. That's a special branch of law than the human rights, which we will not go. But I'm trying to tell you that the human rights are never compromised or derogated. They are universal as well as they are inalienable. So if you look at the Greek Roman philosophers, they have laid down the foundations of the natural law and human rights. So later they are recognized as a legal rights which are enforceable to the individuals. That is why we have the constitutional provisions of Article 32 and 226, and also we have the enforceable mechanisms in the context of the every liberal democratic constitutional orders. So that's the ancient societies. When you come to that, the modern concept of human rights can be found from the famous Magna Carta, where it is considered as a complete charter of civil rights and liberties of individual, because that's the starting point in the modern context. So this particular context, which you see, this Magna Carta gives the bundle of civil rights and liberties to the people. And when it's compared to the modern day, though they are limited, but however, they lays a foundation, and its impact in the world, it's revolutionary. You look at that, the subsequent ages after 1215 AD, if you look at that, how the Magna Carta has influenced 1645, that is the famous Second Civil War between the Oliver Cromwell forces and the King Charles I forces, and where the parliamentary privileges and rights of the people were protected. Subsequently, we have got a Declaration of Rights of the People, and followed by the Charles II in 1688. In between 1648, we have the Treaty of Westphalia, and all these things are now created a platform, and the genesis of this particular platform can be found from the Magna Carta. Okay, so it is a facilitated the realization of the recognition of the rights of the individuals and against every state. Here, please remember that these rights are against the state, because it is a belief that state is the biggest violator of the rights of the people. The reason is that state must be having the brutal power. And against that, if individuals are suffer, then the human rights and the fundamental guarantees which are there in every constitutions expects the state must respect the people's right. So it is expected that state must respect, not to interfere with the rights and liberties of the individuals. That's a basic fundamental idea of the entire rights regime, my dear friends. So if you look at that, the modern concept, what we are talking about, the fundamental rights of man is there in the declaration of various instruments, and also the instruments of various liberal democratic constitutions we can find there. If you look at the Constitution of the United States of America, the French Declaration of the Rights of Man and Citizens, and if you look at the Sweden, Spain, Norway, Belgium, Denmark, and other countries, including India, they have the respective provisions for the fundamental rights of the individuals. So now, as we know that this fundamental rights of man has been for the first time coined by Thomas Paine after the French Declaration of the Rights of the Man and Citizens. Okay, so this is how the emergence of the generation, what we are enjoying the rights today came from the fundamental rights of men to the human rights. And the credit goes to Mrs. Eleanor Roosevelt, who suggested during the time of negotiations in the United Nations General Assembly, aftermath of 1945, the adoption of the United Nations Charter. When the United Nations General Assembly has given the mandate to the Economic and Social Council to draft rights and give the shape to the rights which are there in the United Nations Charter, and they established a working committee under the leadership of Eleanor Roosevelt in 1947. And the term everybody suggests that rights of man, but she was the one who suggested that no, let us have the human rights. And the credit goes. And from India, you can see that Mrs. Hans Mehta from India had participated in that same delegation and represented India. So if you look at that, this generation of the rights which we have from the 1945, which we can found the adoption of the United Nations Charter and the adoption of the Universal Declaration of Human Rights. And that is the turning point in consolidation of all the human rights which are there in the history. Until now, we are tracing which cultures, what kinds of rights they have, how the civilizations are protecting the rights of the people. But if you today, all this bundle of rights are put together in the context of the United Nations Charter and Universal Declaration of Human Rights, and now that consolidation process and the enumeration of the rights have been done in the context of 1945 and 1948. So the United Nations Charter has made a significant contribution and advancement in the direction of reaffirming faith in the respect of the human rights which were there in all the cultures. That's what I want to try to bring my point over here. It's not that alien, and it's not that it's only confined to a particular culture or particular region or particular jurisdiction, but it is from consolidation has happened from taking all the cultures in the direction and reaffirming the faith on respecting the rights of the people in this international document. So now we all ask about that, what is a human right, where you find them, and how you are going to proclaim. So it is a clear answer to everyone is that, let's look at that in Article 1 of the UN Charter. It proclaims that one of the purposes of the United Nations is to achieve the international cooperation in promoting and encouraging respect for human rights and fundamental freedoms for all, without distinction of the race, sex, language, or religion, and whatever it is. So here you can find what the spirit of the human rights, and the spirit of the human rights can be seen the entire United Nations Charter, starting from the preamble, where starting from the preamble, which clearly says that is asserting the rights of the people. If you look at the charter provisions, the charter itself starts with an asserting the rights of the people and concern into that entire generation of the rights. So the human rights concern is woven into that UN Charter like a golden thread. It's like in a thread. It goes into from the preamble to the last article, which is there in the United Nations Charter. So the United Nations Charter, when it was drafted, human rights have occupied a significant chapter in the history of United Nations, because we know what were the political conditions and political ramifications which were there, and they were contributed tremendously for the development of the charter and the principles which are there. So the human rights the promotion of the human rights can be found in various provisions of the charter, including the preamble, Article 1, Article 13, Clause B, 55, 56, 62, so on and so forth. You can look at it, my dear friends, over here. So that means the United Nations Charter is trying to give that consolidation of the rights and promote that, and in order to achieve the international peace and security, and if people want to live in every continent, we must achieve the rights of the people, and the states must not compromise on that. So in order to achieve this purpose, the UN has set up various international norms, standards to observe every human right in every country. So what happens after that? So as I mentioned earlier, then they started with the Universal Declaration of Human Rights and the Commission on Human Rights. where the implementation of all the provisions of the UN Charter concerning the human rights and the General Assembly, the United Nations had decided to prepare the International Bill of Rights for the human rights. In order to achieve this particular agenda, the UN has requested the, as I told you, Economic and Social Council to prepare the draft recommendations and culminate that entire recommendations are culminated in the form of 1948 United Nations Declaration on Human Rights. So this is a very, very momentous occasion in the development of international law. So this UDHR consists of civil, political, economic, social, and cultural rights. And these particular rights, which promotes and substantiates the understanding which is there in the United Nations Charter. So United Nations Charter clearly says that in order to promote the peace and security in the international among the international community, first obligation and first caveat they have done, we need to grant the independence to the colonial nations. Unless you grant the independence to the colonial nations, and also you end that colonialism in all its manifestations, you cannot respect the rights of the people. So that's the first thing. That is why right of self-determination is a prominently taken place in one of the fundamental human rights of the United Nations Charter in Article 1. And the second important principles which gave that recognition of the civil and political rights is that is, if a threat to the peace and breaches to the peace and acts of aggression violates international peace and security, and without achieving the peace and without achieving security, you cannot achieve the rights of the people based upon the civil, political, economic, and social and cultural rights. So that is why all those aspirations which are there in the preamble as well as in the Article 1 of the United Nations Charter embedded into that UDHR and different parts, that is civil, political, economic, and social rights. And subsequently, if you look at that, the developments which took place, that is a covenant on civil and political rights was adopted, and international covenant on economic, social, and cultural rights were adopted by the state parties in 1966. And subsequently, they also adopted optional protocol to the covenant on civil and political rights. And what is that main contribution of this particular document? So that is very, very important for all of us to know. The contribution of these particular documents is making that they're trying to provide a universalization of the rights. As I told you that different cultures are perceived differently, but this particular principles of human rights law, they're trying to give rise and they're trying to give a kind of consolidation effort of all the rights and promoting that. As I mentioned that the paragraphs of the preamble of the charter, and they are conveniently and very carefully taken and made a mention in the context of the both the covenants. If you look at that again, I'm going back to the preamble. The preamble is clearly determines that the fundamental human rights must be protected based upon the dignity and worth of the human person, and also the equal rights of all the individuals and of nations, whether it is a large or small, irrespective of the gender, irrespective of the nations, the capacity. So it is an effort in universalization of the human rights which took place from the adoption of the charter itself. You can see that is in the covenants which we are going to discuss. And again, I will take Article 1, the paragraph 3 of the United Nations Charter. They're trying to dwell with these freedoms without any kind of distinction as to race, sex, language, religion. There is no distinction was made. So this is another effort of making this universalization process. So this is what you have to remember, my dear friends. Like when we talk about that, some of the teachers, when we teach international law, and international law, we necessarily teach to the students is that Eurocentric. But now when we talk about the Eurocentric, is it really a Eurocentric, or is there any relevance of other cultures too? In order to delve into that particular question, you will have to see the charter provisions. whether it is a universal in nature or it is Eurocentric. Undoubtedly, that is the scholars of international law, majority of them have come from Western societies, and they always says that with whatever the pride, they say that, oh, it's a Eurocentric, and others are not civilized and they are barbarians, etc. There is a kind of third world approaches which are involved in this particular context, but we will not go into that. But here, my argument is that the international perspective, what we are discussing today, how they made an effort to give that universalization of the character of the human rights, which we are discussing today. And for subsequently, if you refer to the Article 13 of the United Nations Charter, and again, it talks about that the General Assembly has empowered to make human rights as a fundamental freedom without a distinction of what I said earlier. So because the fundamental freedoms for all have to be observed and promoted universally, and respect for these rights have to be promoted universally. To that extent, Article 55 also gives the clear mandate. And that's the basic purpose of the United Nations Charter. Even if you look at that Article 56, Article 62, that they try to provide a kind of a mandate to all the international community. And they did not leave it like that, only giving the mandate to the international community. What they have done, they try to establish a kind of monitoring authority. If you look at that Article 68, Article 68 of the Charter, they're trying to promote accountability on the part of the state. That is why the Economic and Social Council was set up under Article 68 and made that committee as a responsible for the promotion and the dissemination and implementation of human rights across the world. And this particular Economic and Social Council has set up the commission in both economic and social fields and for the promotion of the rights. So this is a kind of important foundational point to see why we need to have two covenants separately. Because the Economic and Social Council, which is a part of the United Nations organization, one of the organs of the UN, and it has got the mandate from the Article 68 of the United Nations Charter, and trying to emphasize the protection of the rights of the people in all aspects, irrespective of their geographies, etc. And this Economic and Social Council is now trying to promote the human rights and also establish a kind of monitoring bodies where they are making states as a responsible and accountable actors for the purposes of implementing the rights of the people once they become the parties and took the adherence of these principles. As we all know that in international law, the states go to the international conventions and international treaties, they become the parties. Once they become the parties, they just cannot sit in ideal. They have to come back according to the procedure and according to the constitutional mandate. They must promote and protect and implement those obligations in our constitutions. Once it is there, then it is very essential for us to implement that one. The last point in this particular paragraph in this charter, that is 76. The 76, which stipulates that very important objectives. You know that now we have the trusteeship council and also we have mandated territories, but now there are not many are there. But because of the thought of the colonialism, they created the trusteeship system, both the League of Nations as well as in the United Nations Charter. League of Nations in Article 22, you can see how this trusteeship and mandate systems have come. So that is a grand agenda. When we talk about international law, that is a grand agenda of the international community, how they have to do about the colonialism and the colonial occupations. But even though when it comes to the charter provision, particularly 76, it stipulates that it is the trusteeship system is to encourage respect of the human rights and the fundamental freedom among the trust territories without any kind of a distinction. And even the trust territories must not be under the alien rule. The fundamental freedoms must have to be given. the colonialism and the racial occupations must be end in all its dispensations, in all its manifestations. You cannot continue to have this kind of occupation and say that, yeah, we need to protect the human rights of the people. That's the very important point of United Nations Charter. This United Nations Charter and try to fill most possible or try to address all the possible issues which are faced by the international community during that particular context. So further, if you move, the emergence of the current the treaty mechanisms. So the entire idea of the protection of human rights and the fundamental rights were initially during the time of adoption of the charter, it conceived in the Atlantic Charter. I think all of you know about it, and I don't require to mention all of them here. And the Declaration of the United Nations through the Atlantic Charter, and in 1942, and followed by the Dumbarton Works proposal, and also San Francisco Conference, and all these things, they try to make determine and give the references to the International Bill of Rights and the International Declaration of the Convention on Civil Liberties and the Status of Women, and prevention of discrimination on the grounds of race, sex, language, and religion, protection of the minorities, and other rights concerning to the human rights was embedded into the entire United Nations Charter and Universal Declaration. So the Universal Declaration is the basis for the Economic and Social Council to prepare the two covenants which we are talking about, Covenant on Civil and Political Rights and International Covenant on Economic and Social and Cultural Rights. And so that becomes an entire gamut of international human rights law when it comes to from the perspective of the international aspects. Now, quickly, I will deal with what other conventions we have. There are key instruments which are there in international human rights law. When you look at that, there is optional protocol to the Covenant on Civil and Political Rights, which adopted again in 1966. The second optional protocol to the ICCPR, which aiming at the abolition of the death penalty. I think almost 125 to 130 states. I don't know the exact number as of now, but they all prohibited the death penalty. So that's one of the interesting the feature of this optional protocol. And now we have the draft optional protocol to the International Covenant for Economic, Social, and Cultural Rights, which was adopted in 1985, but still that was in the draft form only. So now, apart from that, you see that we have the various mechanisms, that is protection of the child rights, which I'm going to talk about that, and the protection of the women and the discrimination against women, and all these things we have under the international covenants. And apart from that, these are all mechanisms which apply to the situations of any kind of situations. But what happens during the situations of armed conflict? During the situations of armed conflict, the international law has given the mandate to the international humanitarian law. There are 4 Geneva Conventions of international humanitarian law, and also subsequently adopted protocols, and the 2 additional protocols, which gives that the binding nature of human rights, which could be applied during the situations of armed conflict, whether it is armed conflict of international in character, or armed conflict of non-international in character, or insurgency, or any kind of situation. The state cannot compromise on the protection of the rights of the people. If you look at that Article 4 of the ICCPR, and it gives the mandate, even the nation's security is at a threat. In the pretext of the national security, you cannot compromise on the rights of the individual. You cannot have this kind of debate saying that which comes first, whether it is the national security or the protection of the rights of the people. But human rights, it is always the protection of the rights of the individual comes into the first. To translate that particular ideals in international humanitarian law, there are very important provisions, particularly in additional protocol 1. If you look at that Article 72, there are list of fundamental judicial guarantees which are given by the IHL treaties to be applied during the situations of international armed conflict. In the non-international armed conflict, if you look at that Article 3 to the 4 Geneva Conventions of International Humanitarian Law, and additional protocol 2, Article 4 and Article 6, which talks about that specifically protection of the rights of the people during the situations of internal armed conflicts. Now, you know that, majority of the conflicts which are going today, they are internal armed conflicts or maybe situation like insurgency. And this situation like insurgency, state must not compromise on the rights of the people. So hence the IHL treaty mechanisms were there. So subsequently, to prosecute the people, those who are violated in IHL treaties, we have the international criminal system. And now what happens in the context of human rights law? In human rights, if the state is an obligation, the courts have to be empowered, and the states must adopt the legislation, and they must enforce to the extent of people. If the states are failed, they are not able to protect the people from all kinds of dangers and all kinds of violation of the rights, what they're supposed to do, then they must talk about that, referring to the international monetary mechanisms. Every key convention, they have the monitoring mechanisms. So now that the monitoring mechanisms works like this under the office of the UN High Commissioner for the Human Rights. And they established a monitoring of the human rights. And every periodic reports have to be submitted by every country, those who are taken the international obligations to these monitoring bodies about the implementation of the ICCPR, implementation of the ICSCR and Optional Protocol 1, and also implementation of Child Rights Convention, elimination of Racial Discrimination Convention, and discrimination against women, rights of the children, Convention against the torture. All these things must have to be reported back to the monitoring. That is how the enforcement of international human rights law is taking place. Now, quickly, I have very little time. I'll quickly go into the details of the Indian law. Like if you look at that in Indian context, the starting point of our human rights mechanism, Indian Constitution. First, I will take Article 53, Clause 1C of Indian Constitution, which gives that idea of respecting the international obligations and international human rights treaties and United Nations Charter and all the international treaties, whether it is a bilateral or multilateral, must be respected by the people of this country. That is the binding obligation, though it is mentioned under the directive principles and duties, but it is obligation on the part of the state. If you look at that, these obligations must be taken by the state, it must be implemented by invoking Article 243 and 256 as well as Schedule 6, which talks about that the entire implementation of international law obligations into the domestic law. Once we have this law, the state must adhere to the principles. Once the state must adhere to the principles, the implementation of that particular mechanism, how these conventions have been adopted, how these conventions have been taken as a domestic legal system, that has to be reported back to the monitoring committees which are there in the human rights law. Of course, generally every country, they fail to give that regular reports, periodic reports. That's a mandate given by the Human Rights Convention. But sometimes when the reports are given and the government will go back and say that, oh, that report is a forge and they did not visit the country, they did not take into confidence of the ministries, etc. You get to hear those many things in the United Nations platforms these days. If somebody come and say that, oh, in your country, in such and such part of the place, human rights have been violated, immediately the Indian representatives will go and say that, no, that is the report is not concocted, it's not correct, and you have not taken the ground reports. All these things goes on. So that means, even though the kind of debates and discussion goes on, that reflects the idea of an effective implementation of the human rights law in our country. So in order to give that kind of enforcement, we have made a specific legislation in 1993, the National Human Rights Act, which promotes human rights implementation in India, which is one of the independent bodies which are established in accordance with the Optional Protocol 1 of the International Covenant on Civil and Political Rights and the Paris Principles of 1991. And these Paris Principles, which gives rise to the obligations to all the state parties, and they must establish the National Human Rights Commissions. And these National Human Rights Commission, they must be a constitutional body. It has to have the constitutional mandate, and it must be work independently, and they must have the autonomy, even financial autonomy, functional autonomy. So they should be equipped by the government in order to promote and protect the human rights. And in 1993, the National Human Rights Commission, which was established through the implementation of the Human Rights Act of 1993. Okay, that's one of the excellent mechanisms we have. So that national commissions must also facilitate the establishment of the state human rights commissions. Then the state human rights commissions must be empowered by the state governments in order to monitor the implementation of the human rights which are there in the constitution and the obligations of the international law which we have taken. That's another effective mechanisms. We did not stop there. It went on to the even look at the judiciary. The judiciary has got very, very effective implementation of the human rights. You can take as early as 1950s. If you look at the first famous case of the A.K. Gopalan, it's about the detention of the individuals and violation of the personal liberty. One of the very first landmark cases which have come to the Indian judiciary, and the courts have given a wonderful judgment based upon the jurisprudence of the developed countries by then. That's one of the landmark cases. So if you look at that, the journey of the protection of the human rights from 1950 onwards until today, the courts are, though sometimes they have failed, but they are standing to protect the rights of the people. If you look at that, the cases particularly in the context of the 1970s, 1980s, it's a judicial activism which created, they gave implementation not only to the civil and political rights, but economic, social and cultural rights. The first reference point to this economic and social rights, you can refer that Volga Tellis case. What the Supreme Court has said. The Supreme Court has mentioned in a very categorically about the effective implementation of the socio-economic and cultural rights, which are part of the directive principles of the state policy, where our constitutional law teachers goes to the class and they say that they are not unenforceable. Fundamental rights part 3 is enforceable, part 4 is not enforceable. But now we need to stop that. We need to stop that. The enforcement of the social and economic cultural rights have given a kind of a leap and the kind of acceleration by the courts, not only the courts. And today the normative practices are that without realization of the social, economic and cultural rights, you cannot enjoy the civil and political rights. So that is why if you look at that, the one of the very progressive constitutions which adopted in recent past, the 1995, that is South African Constitution. And by looking at the Indian Constitution, they have given the enforcement of all the social and economic rights, but they have seen entire jurisprudence. The South African jurists, while they are formulating their constitution, they have read entire case law, what we consider today is a judicial activism, giving acceleration to the socio-economic and cultural rights. And that particular rights they have taken and they made in their constitution as one of the enforceable rights. So that is one of the very, very interesting the chapters of India. In spite of having whatever the troubles which we experience, whether it is emergency, but emergency is a testing time for the human rights. What happened after the emergency? We bounced back. We bounced back and trying to reaffirm the faith and the fundamental rights of those people. And the Constitution has made such a kind of a big contribution. And if you see after that in 1993, even though we are not party to the, we are now taken obligations of international law and implementing, the Vishaka case has said that the courts will not stop until government ratifies or take the obligations of the Convention Against Elimination of the Discrimination Against Women. We will implement that, and Justice Verma report on that particular context is very one of the landmark. If you keep on tracing this origin and implementation, whether it is a Vellore Citizens Forum's case or recent judgments like whatever the Supreme Court judgments given in the Aadhar's case, or maybe in Sabarimala the judgment, all these things stand as a kind of reflection on the effective enforcement of human rights in this constitution. So, my dear friends, I think I don't want to go on and on and on this. I can, but I'll stop it here. We have a few more minutes before you're going to start the next lecture, maybe we'll take some questions and I'll rest my case. Thank you very much.
Thank you, sir. Thank you for that wonderful address. As of now, there are no questions in the chat box. Dr. Aparna ma'am, are there any questions on your end?
No, Mihir, I could not find any questions from this side.
Okay, so if you don't have any questions, maybe I can provoke somebody to ask the question.
Yes, yes, sir, that would be great. Actually, maybe
Okay.
the participants are much satisfied and they have got to know about the international perspectives well.
Yes, ma'am, international.
International perspectives, international development, how it has occurred, and very nicely you have narrated the not only the historical things but also the implement in the national domain. Sir, will you please highlight certain areas like NHRC and the role of NHRC in consonance with the principles that we have accepted at national?
Okay, so I think the role of NHRC is a very vital, but unfortunately, but in current days, it's a kind of an academic thing, and we are not able to enforce. But this particular the NHRC is one of the very effective means of implementation of the UN human rights institutions in every country. As I told you that after 1991, the Paris Principles gave the obligations to the countries, and they have to give the effective implementing mechanisms of all the people, and they should be able to enjoy all human rights and fundamental freedom across the world. So that is why these particular Paris Principles have given the mandate not only to the states but also regional organizations. We have so many regional human rights mechanisms which are playing a very vital role in promotion and protection and enforcement of the human rights on a regional basis. For example, European Union, they even established a European Court of Justice, and African Charter of Rights and Freedoms of the People, and we have the Organization of American State, and we have that like that everywhere. But in Asia, that is one of the conspicuous gaps with regard to the regional promotion of the human rights because of the various political and geographical divergences. And these regional mechanisms, they develop policies and case law, and that put international human rights standards in the context of the particular social, historical, and political traditions and regional realities. That's very important. But unfortunately, in Asia, we don't have that such. And these regional human rights mechanisms and national human rights institutions have a kind of a symbiotic relationship. They have a kind of relationship in promotion and production of the human rights based upon the regional and local expectations. And these human rights institutions, as I told you that, they are the state bodies. They need to have a constitutional obligation and also constitutional mandate, and they need to have the legislative mandate in order to protect and promote the human rights. So that is why we have got that amended our constitution in 1993, and we have brought that implemented the National Human Rights Act of 1993. And these national human rights institutions are the cornerstone of national human rights protection system, because they increasingly serve and realize the rights of the people, and they act as a kind of bridge between the human rights norms of the international mechanisms and the domestic norms. And these NHRIs are unique. They do not resemble like their governments. They have to function autonomously. They have to act independently. But no. How independently they are acting, I don't know. That's my biggest question. And they should not be under the direct authority of the executive, legislative, or judiciary. Although they follow all the constitutional mandate, their accountability and the legislation mechanism entirely, they should be directly answerable to the people. That is why the NHRC, they every year the periodic reports of NHRC in India, they directly place in the parliament for the discussion of the members of the parliament. Why? Because NHRC is directly responsible to the people. though they are established by the state legislative mechanisms of the parliament, because we are electing the representative and the representatives are responsible to answer to us. Hence, the NHRC is expected to give that their periodic reports to the parliament. So that is, they are at kind of, they should act as a very independently, though they are funded by the government, and they should not be part of the government processes. And again, this National Human Rights Commissions, they are not NGOs. They have the statutory legal basis, and they must act neutral manner. And they are not the advocates of one particular side, either government or this individual. No, they have to act neutrally. So that is why in India we have various the functions of the National Human Rights Commissions, and they have done a wonderful job. If you look at that, the contribution of the National Human Rights Commission in India last 30 plus years, and if you I think almost 40 years, the establishment of the NHRC, and this has made a tangible contribution for the promotion of the human rights in this country, whether it is the case of the lockup deaths, whether it is in the case of the encounter killings, or in the case of the Chakma refugees. The NHRC made a kind of a tangible intervention. We have the famous cases, NHRC versus state of Arunachal Pradesh, when the Chakma refugees were not given the basic rights, and they clearly said, it is important, the human rights are not limited to the citizens, but to all the individuals. It's a universal in nature. Now, I'm just going to give that kind of a provocative statement right now to all the students. Now, when we have that kind of a record of respect in the human rights of even refugees, but today it's not happening. We are now trying to stop the refugees, those who are coming from the different parts of the country. The reason known to all, because of the political compulsions. In international scenario, if you look at that, the Syrian refugees were not welcomed across the globe, because they were treated as they are something, they are coming to their countries to occupy, and they were called as an illegal immigrants. So that is where I'm trying to look at that. In 1951, when the Refugee Convention was adopted, and where this Jewish and European refugees are stranded in the European continent, and they said that, come on guys, we need to accommodate all this program. We need to accommodate all these people. But now what happened? When the refugees are emerging from Asia and Africa, now the European countries are closing their doors. They're constructing the walls. We have seen Donald Trump said that, oh, we are not going to allow them. We will build the walls. So, can you build the walls? If you build the walls, what happens to the fundamental principles of the non-refoulement? You cannot send them back. The non-refoulement, the principles of non-refoulement in international human rights law and international refugee law is a customary principles of international law. In international law, as a student of international law, we call it as a jus cogens principles. What happened? That's a one controversial thing. Now, even United Nations, they come out with the compact, global compact on safe and secured migration. They're changing the language. Now they're not calling us refugees, they're calling us migrants. Wow, that's a very, very important thing we see. Now the human rights are diminishing. The moment if you talk about you're a human rights student, human rights lawyer, you will be looked with in a suspicious tone. But that's not the one, my dear friends. Now we are in the kind of crossroads today. Puttaswamy judgment is there. Aadhar judgment. We all knew that privacy is a now integral part of the Article 21. The court said so. But how many of us are not giving our Aadhar number? If you go to the bank, if you go to the universities, and if you go to whatever, I don't want to spill the beans. Without Aadhar, you just can't move now. But court said that you don't require. The privacy is a fundamental. And also now, in the age of digitalization, today we have a lot of problem with the digitalization. It's good. They can facilitate us like that. Sitting in some 1,000 kilometers away, I can speak to you. Good, fantastic job. But This technology is trying to creep into your personal lives. And technologies are making into your personal life and taking out your privacy. And people are making money out of your data. The big data is becoming a kind of a boon to some people and giving good money to the people, but at the cost of your privacy and your private rights. So please think about that. I think I'll stop it here. My time is over. I do not want, and my sir is there already. Hi, sir. Good morning.
Thank you so much, sir. There are two questions in the chat box, but I suppose during your discourse you have dealt with both the questions. One question was about the implementation of how it is being implemented, international documentation, how it is being implemented in India. That was from Mr. Kaushal. And there was one question from Mr. Dande, and I suppose the same question also has been answered from your side. He was asking about your opinion. If enforceability of these human rights, which we have talked about at international level. So what is your opinion in this regard for establishing the peaceful society? Whether the human rights are being really implemented, whatever principles we have accepted, are they really implemented?
Yes,
And
my dear friends, they are. Because see, today if I am freely speaking, that's enough. Implementation of effective implementation of Article 19 of UDHR and Article 19 of Indian Constitution. Freedom of speech without affecting the sentiments of the people. If I can freely, that's we are in an effective implementation. Thanks to the judiciary, whether it is a national judiciary or international judiciary, they are able to protect effectively our basic rights, number one. Number two, look at that series of the rights. In international mechanisms, international law gives only obligations to the state. It is the state you have to do it. But if the state is failed, or they are conducting a sham trials, or they are not willing to, or unable to, then we have the international mechanisms, where we have seen that examples, particularly in the context of the European Union. The entire European Court of Justice, the judgments given by the European Court of Justice in specific matters of a human rights violation, that becomes a binding on the each state in the regional mechanism. Likewise, in international law, if you international mechanisms, if any specific tribunals has been established for a specific purpose, like I refer to the various tribunals in international law, international humanitarian law, and they are binding on that particular parties. I will specifically take one example of India's related. We have all seen that Kulabhushan Jadhav's case. India has contended that he was not given proper consular access, and he was summary trials and summary proceedings were initiated against him, and he was not given proper, he not implemented proper rule of law and justice system under the criminal law. And immediately when they went to International Court of Justice, International Court of Justice said, okay, thank you. And then they gave the direction to the Pakistan government. No, yeah, you're not following the basic principles of the due process of law, which is existed in the criminal justice system, in international law, human rights law, which are also part of your constitution. You must follow, whether he is an alien, or whether he is a spy, or whether he is a illegal immigrant, whatever the reason, must follow the procedure. The procedure established by law has to be there. That is the judgment given by the ICJ, not judgment, opinion rendered by the ICJ in the context of the Kulabhushan Jadhav's case. So I think that is how we effectively implement, my dear friends. That's just one example. I can keep on citing so many examples, but due to paucity of the time, I'll stop it here.
thank you, sir. Mihir, please continue with.
Yes, ma'am. Thank you very much, sir, for also answering all of the questions. We are now arriving at the concluding part of this session. On behalf of ML and GE Society, I express my deepest sense of gratitude to our resource person, Dr. Banerjee sir, and also Professor Suhas sir, for introducing the sub-theme to us. Also to our attendees who joined and asked such a great, insightful questions. I am also grateful to the organizers who gave me this opportunity to anchor this first session for you. Our next session will focus on rights of child and will feature respected Professor Dr. Nirmala Ma'am, Grad Professor of Law at Andhra University. I would hereby like to formally conclude the first session with the permission of dignitaries, and I would also request my peer, Ms. Damini Sharma, to take over for the second session, which will begin shortly. Thank you all.
Thank you very much, all. Nirmala ma'am, good morning and nice to see you. Thank you so much.
Okay, it's nice. I heard your speech also. I heard.
Thank you very much, ma'am. Thank you, ma'am. Yeah.
Okay, thank you.
Okay,
I'll try to
bye-bye.
contact you later.
Yeah. Thank you, ma'am. Thank you very much, ma'am. Aparna ma'am.
Okay. Okay. Okay.
Ma'am,
Thank you,
can I
sir.
start?
Yes.
Thank you so very much, Meher. A very warm and pleasant morning to one and all present here. I, Damini Sharma, from BA LLB third year, Manikchand Pahadi Law College, welcome you all to the second session on online training program on child rights on national and international perspectives. I find it immensely fortunate to be given this opportunity to introduce Professor Dr. Anisha Sheikh Ma'am, who is an Assistant Professor of Bharati Vidyapeeth University, Pune. In this session, our resource person, Dr. Anisha Sheikh Ma'am, will discuss right of child, rights to their survival and development, right to participation, and right to their protection. I would request ma'am to kindly introduce the sub-theme of this session. Thank you so much and over to you, ma'am.
Yeah.
Good morning, respected Rao sir.
My side or your side? Resound.
Hello.
Respected Nirmala ma'am, it is introduction of sub-theme on which Dr. Anisha Sheikh ma'am would be introducing the sub-theme within a minute, and then the session will be yours. So I would request Anisha Sheikh ma'am to introduce the sub-theme within a minute. Anisha ma'am, over to you.
Thank you, Aparna ma'am. Thank you, Rao sir, for giving the opportunity to introduce some points of the second session. Second session is about rights of child. Rights of child, that is rights relating to survival, development, rights of protection, and right to participate. So second session is about specific rights, and these rights are supported by Article 41. India is signatory to UN Convention on Rights of Child from 1992. And UNCRC has given obligation on every nation to help children, and this obligation is on every state, every country. India has evolved all the laws and policies to protect and empower its children through the cases as well as through some laws. The first right is right of survival. Right of survival includes right to life, and right to life include right to protect essential needs, that is nutrition, shelter, living standard, and medical services. Right of development, that is very important and most important right of every child, that is right of education. Right of education is the supreme right in its regard, and it helps the children to develop all round. The next right is right of protection, and the protection is from abuse, neglect, and exploitation. It is the obligation on every nation to create child-friendly justice system for rehabilitation, And through some policies, the government should protect rights of child from protecting exploitation and abuse. The last right is participation rights. The child's freedom will be protected only when the chance is given by freely expressing their opinion. So that was all about protection, survival, development, and participation. Thank you, Aparna ma'am. Thank you, the organizers, for giving the opportunity to introduce the session.
Thank you so
Yes.
very much. Thank
Shall
you
I
so very
start?
much, Anisha ma'am. Now, I am profoundly delighted to take an opportunity to introduce the chief
Is
guest
it
for
audible,
the
ma'am? Yes. Aparna?
Ma'am, you are audible, but Damini is attempting to introduce you, giving the brief profile. Damini, you can continue with, please.
Okay, ma'am. I am profoundly delighted to take an opportunity to introduce the chief guest for the day and a master teacher, Professor Dr. Nirmala Nadella ma'am. Dr. Nirmala Nadella ma'am, who has been working towards connecting young minds to strive towards success and achievements, was born on 13th of April 1957. Ma'am has completed academic requirements of BCom and Masters of Law and has also done PhD in Law. Ma'am has rendered her 33 years of service as a law teacher in the prestigious Andhra University from 1986 to 2019. Ma'am has also guided 8 PhD scholars who are related from different fields such as corruption related issues, minority rights, alternate dispute resolution, their role of PP in criminal justice system, in armed forces, which includes domestic workers, etc., and also guided nearly 80 law scholars in their dissertation and project works mainly in the areas of labor law, family law, criminal justice system, and human rights. Professor Dr. Nadella ma'am has written several articles in reputed national journals on issues relating to women rights, labor issues, etc. Ma'am has also attended and presented her papers in nearly 60 national and international seminars covering varied areas like women-related issues, intellectual property rights, etc. Ma'am was also associated with the Sexual Harassment Complaint Committee of Andhra Pradesh and with a project conducted by Andhra Pradesh Academy of Rural Development for giving a training to ward members and men and women sarpanch of village panchayat of nearly 10 mandals of Vishakhapatnam districts for 2.5 months in 1999. Ma'am has also written 2 books so far titled Trade Union and Collective Bargaining and a Law Relating to Civil Servants for the LLM program. Even after her retirement, Dr. Nadella ma'am associated with Dr. Ambedkar College of Law and DS and LU as a visiting professor and also guiding PhD scholars as the main guide in the areas of labor law and cyber crimes. Dr. Nadella ma'am is also presently running an online digital magazine covering important issues on economic, social, cultural, legal, and human rights under a blog entitled Bonafide Voices. It is a moment of indeed equal-side delight for us to have you, ma'am. Thank you so very much, and over to you, ma'am.
Hello, good morning to all of you. But some resound is coming. Is it from my side or your side?
Most probably it
Yes,
is from
Aparna?
your side. If yes, ma'am. If there are 2 devices on, maybe that is the reason. And from our side, no 2 devices at a time are
No, there is
working.
resound.
Yes, resound might be from your side, ma'am.
Technical problem.
Technical issue is there.
Is it clear?
Yes, that way it is clear. No issues, ma'am. We can continue with.
Okay. all of you very much the significant event, this training. Manikchand
Ma'am, you are not audible.
college, Dr. Manikal Rao garu and Dr. Aparna was coordinated and who have been in touch with me. I'm very thankful for making me, take this opportunity. Very, very thankful to you. So here, I'm being assigned the CRC, that is the Convention on Rights of the Child, to give, instead of already the Banerjee, Chika Banerjee has given entire from the to focus more on some of the ground realities. So I'm associated with some of the social activism and all the things. So I thought that it is better. I just, because in the other panelists also, they are concentrating on the child labor and child abuse issues. Some I'll just throw some issues so that because a lot of I'll start with some what you call ground realities. So before I start with actually the subject, actually the present position, the children are exposed to vulnerability right from the ages. Ages. It so happened that they before in the beginning they were involved in the war. They were the targets. And also in certain conflict areas, they were the perpetrators as well. Targets, the victim as well as the perpetrators. They were forced. International organization. They involved 18 years of age in the conflict areas, especially as perpetrators. Some of the terrorist organizations and other organizations at the international level, right from the beginning. So we can observe that these children have been victims as well as perpetrators. This is one of the important area which we have to focus much at the international level. In the national level also, we observe here, and the conflict areas, especially where internal conflicts take place, especially the children were so much vulnerable, and they are used, they are attacked as victims. They are becoming victims of the conflicts, and also they are perpetrators, especially in some of the terrorist organizations inside our country also. So that has to be, it is an important aspect which has to be focused much. And secondly, when you observe that, street children, those who are homeless, those who are abandoned and neglected children, and all these people, mostly they are involved in the rat picking and what you call they are called as market children. Are actually, in fact, involved in all menial jobs, and they are forced to the robberies and other associating with the elder accused, elder offenders, Especially they are abandoned. Sometimes when they are neglected, the main causes for the street children is at homes, they are neglected, they are sometimes abandoned by the parents who are indulged in what you call alcoholism, drugism, and all these sorts of illegal activities. In fact, this most of the street segment which has to be concentrated, which is a worrying factor for most of the social activists, and also for the entire what you call this socially concerned citizens. That is one area where we have to think, about it, And sexual abuse is on increase. Like I'm not going to the statistics, just we'll try to first of all identify the problems and what are the strategies that are to be adopted by us and what are the initiatives that are taken by the government. Yeah, no, this includes like emotional, sexual, and what do you call this? All sorts of sexual harassment, rape, molestation, all sorts of things. This is also one of the worrying factors currently in our country. So this actually, the sexual abuse, this is there right from the beginning, right from the beginning, which has not come to forefront, especially after this social media and awareness and other able to, even though it has been traditionally continuing for a long time offline, this online sexual abuse, also this what you call pornography, child pornography is on the, after this, the development of our technology, internet and all these things, this child abuse is on increase. Child sexual abuse is also all increase, phenomenal increase there, and which is very also for the purpose, it is so here, this is one of the a lot of efforts were made. I think that minors of it's almost on an increase, children. That also is a worrying factor, one of the other concern factor which we have to concentrate more. And another area which detail, that is child labor. Child labor, especially about what happened right from the beginning. Traditionally, if you observe also this, and I just try to point out this before it. Surprised to note that legislation in 1881 I mean 7 years. It is fixed at 7 years. That means prior to that period, even children below 7 years were made to work. This is other situation, especially it continued after independence in what you call crackers, match industry, and also carpet. Still continuing.
Ma'am, you are not audible to us.
As well. But still, you try to understand. The children can never, it is very difficult for them to exercise the citizens, in fact, like freedom of association, freedom of expression, and all these things they'll be suppressed in such a way that they can't express their feelings also, so that these freedoms cannot, whatever rights we discuss from the, and mostly even the social activists and others, or the government, especially the state government, the city government, only, and they address from the protectionist point of view, not from rights point of view. Problem is they think that actually they have to be protected. Parents, political parties or organizations, what protectionist approach and not rights approach. This is another important issue which we have to address at particular aspect. This is one thing. So, child labor. Now we will try to actually what the government has initiated, that we perspective also. Already he has said that given assigned to this convention on rights of the children. Actually, I mean, what do you call it? This is based on the human rights concept. You know, whatever the human right, the Universal Declaration of Human Rights, Universal Convention, the United Nations Convention on Civil and Political Rights. These both this can other convention is UN Convention on Economic, Social, and Cultural Rights. You know, all these rights actually has been basis for our what you call this Convention on Rights of the Child. Basically, they have been categorized as 4 important rights. That is actually all this particular CRCC based on the principle that all children are born with fundamental freedoms and all human beings have some inherent rights. These are the inherent rights, inalienable rights of the children which are provided under this particular convention. The convention has basically taken into consideration the humanitarian law, humanitarian conventions, and the human rights conventions as well. That, you know, your basic principles are right to survival, right to life, health, and right to development, education, care, leisure, recreation, and right to protection from exploitation, abuse, neglect, and right to participation, to express information, thought, and religion. Just peripherally, I'll go through this page, you know, instead of each and every detail, which you can bet we are very all the students are very, they can access to these very easily through the kind of. So I'll try to just discuss about the round-the-mill. Right to survival, right to life. This basic right to life, you know, we have seen that, you know, in practice, actually what is happening, the what you call right to life itself is at what you call it is in danger. It is endangered because the problem is because the child has there is lot of what you call infant feticide and infant feticide. Infanticide is also taking place in a large scale right from the beginning. We observed it. You know, it has been on increase of late, especially sex selection tests. You know, initially people, you know, up to 80s, 90s, and all these, they never wanted the girl child. Other things, you know. So they were trying to, even the girl's position was so vulnerable that they were right in the infanticide and feticide, infanticide, you know, all these had actually put the girl child in a very, very vulnerable than the boys. You know, here it is not only the cultural norms, you know, nowadays, you know, when one of my scholar, you know, when I asked him, he said he doesn't want girl child. I said, what is it? You're so much educated and why you're talking like this? He said, keeping the present situation, not that is, madam, I like the girls very much, but the problem is in the present society, it has become very difficult that when the child rampant manner, and no, we are unable to protect our own child, even whether it takes place in the while transport to the schools, So we have to take, our parents are so much worried that they themselves are to take care of and take it. At any stage, children are exposed to such vulnerability and such this what you call child abuse at every point of time. That is the reason why I said I don't want a girl child, madam. And what you call the concern of the people and our the trauma which they are undergoing, not to have a girl, not because because of this getting married and other things like the traditional thinking, but keeping the child abuse in this violence which could not be prevented even by the state, even though it is responsible to take care of such things, even though it is constitutionally mandated that the state has to take up the responsibility to protect the child, but still, here in actual fact, this is what is going on. So these social and all such things actually has and the child abuse which is going at the what you call it rampant stage. This has created a what you call a sort of insecurity among the people with regard to this. So this is a right to life actually is endangered, especially in the conflict. As I said, the conflict areas, they have become the also most of the children, in fact, it is very, I mean, very much with much concern and agony. I'm constrained to tell that actually, what you call this here, this girl child has been used as what you call they are forced to prostitution, and their children in prostitute houses also they are stigmatized and they are inaccessible to the school facilities also, proper school facilities. And of late, another important thing is these children are exposed, some of the social activists are getting, I mean, they are imprisoned for various reasons, their children are also, most of them, most of the social activists and others, who have been taken into custody on some, and that we can discuss, and that is another debatable issue, whatever it is. Their children are also at risk now. Nobody is there to take care of such children. And most of the people who are, I mean, some of the organizations who are banned organizations, whatever. So these are, when it comes to the right to life, lot of threat is there to the children that has to be safeguarded. And it is the responsibility of the state to see that, this involves the executive, what you call the judicial intervention and judicial activism, and all, even when it comes to the what you call whenever there is a threat and whenever there is a sexual abuse to such children, in fact, when it comes to the what you call I mean, not proper action is taken by the police police executive cadre for various reasons, for various reasons. I'll be talking about this also at a later stage. So here, health and nutrition. I mean, it is a state responsibility under Article 39 to provide, I mean, what you call the nutritious and healthy food to improve the nutrition and health condition of the children. That's one of the responsibilities of the state under the Article 39. And also, they'll be given, 39F, they will be given the opportunities and facilities to develop healthy manner. They have to be brought up in a healthy manner. And actually, the CRC insists that there should be a family atmosphere, a lovable atmosphere, an atmosphere of love and understanding, and that must be there. But actually, the unfortunate situation is that here in our country, and most of the countries for that matter, all the developing countries, health and education, in spite of the pronunciation, I mean, most of the economists, they say that actually it should be under the state purview. but still, health and education, they are the two important things in order to protect the children and all the, for that matter, all the downtrodden. This has to be, which we have experienced in the this pandemic situation also, how people have suffered, how lot of lives have been taken away because of their inaccessibility to the medical facilities, timely medical facilities, and all these things we have observed. We lost so many people, and even during this pandemic period, the children of this, some children lost both the parents. So now we have to question. I don't want to. I want to put all these things for your understanding and analysis. So what role the states had played during the pandemic period for the purpose of actually protecting the children? For protection, actually some might have adopted them, but that is not the case. It is actually, and I know a number of cases wherein, in spite of declaration by the states, these children actually were not given the assured amounts also. In most of the states, this happened. In Andhra Pradesh, it has happened, and we were in fact, witnesses to such things also. So here, the children right to life and health, nutrition is at stake. In spite of the fact that it is a state responsibility, the children are not provided the proper. They were not brought up in a proper healthy condition. That is one thing. Nutritious food is not provided for them. Most of some nearly 80% of the children, 80% of the children, they belong to the downtrodden. Whatever the 40% of the total population of our children, and nearly 70 to 80% they belong to the downtrodden, where they did not have access to the educational facilities, not the public health facilities also. In spite of the fact that some initiatives were taken by the state in providing this, government hospitals are there, but they're not proper doctors, and all these things are there. In actual practice, actually, they are not access to the good medical provisions, and also and nutritious food. This is one of them. And as far as this, education is concerned, this is again a debatable issue. Actually, Article 45 speaks of free and compulsory education up to, 14 years of age. That is right, 6 to 14, 14 years of age, free and compulsory education. This particular directive principle has been given a fundamental. It has been elevated to fundamental right. In I think is it 2002 to 86th Amendment, wherein, and then it has been under Article 21A. The thing is here, and even in 2009, it has been given a legislative effect. That is, Right to Education Act of 2009 has been passed. Here. The problem is, it is the 6 to 14 years of a free and compulsory education system. But it is also provided under the rules that 25% of the downtrodden people who belong to the backward classes, they have to be given here. 25% admission must be given in the private schools, also corporate schools and other schools. So a mandate was given, which is very good. But in actual practice, many social activists and many studies reveal that actually most of them, they are not giving one thing. Even if they give also, they are stigmatized sometimes. They were stigmatized that they got on this and that. They are not properly treated also. They are not on the equality, equal treatment was not given to both these people. Just like when the reservation candidates were in the professional colleges, medical and other colleges, like that. So this 25% is also on, theoretically it is there, but in actual practice, most of the schools, they are not providing this. Because what, Checkup Energy and all these people are saying that in actual judicial directions are there. those judicial in environmental protection of environmental protection also in other things, in social, they have even directions for the purpose of protection of women, protection of the children, and so many directions. But actually in implementation, the problem arises in the case of implementation. Most of the cases, I cannot give each and every detail of it, but the studies, overall the studies reveal that actually this is not properly being implemented, which we are witnessing in our state itself. Through our friends, we are getting the information. We ourselves, we sometimes, some of the group, our group actually, we visit some schools and wherein we find that we have taken actually some of the children, backward classes children to the schools where they are. No, it is not viable for us, madam, to admit these children. So that is how we can't. So this has to be linked up child labor. Child labor is from even from the point of the constitution. Actually, Article 24 prohibits child labor. That is any child which is below the 14 years of age is not supposed to work in what is hazardous activities. But it's non-hazardous activity they can work. But see. This in 2016, they tried to, Mines Act also prohibited and some of the legislation, some of the activity, the Mines Act is prohibited and the children below 14 years, they are prohibited from working. And sorry, 18 years. It is 18 years. And in other plantation and other, the Practice Act has prohibited children below 14 years of age. But 14 to 18 years children, with medical certificate, they can work. They can work also in that provision is there in the Practice Act. Work also in hazardous activities. That has been caused a lot of criticism. Subsequently, in 2016, they tried to impose this and brought an amendment to this act, which says that actually the children 14 years they are prohibited from working in all the activities. Hazardous, non-hazardous, or whatever you see. And here, in the case of what you call the children who belong to 14 and 18 years, they cannot work in hazardous. They also cannot work in hazardous. So some effort, some improvement with the public criticism, civil societies, pressures, all they have been making it. But this has to be linked up actually. This right to education, free and compulsory education. If suppose this particular age of employment has to be in consonance with the compulsory education or the maximum age to the extent of which the compulsory education has to be imparted, it is 14 years. Actually, ILO, that age of employment, the minimum age of employment was fixed at actually it is 18 years, but 18 not as long as compared to whatever extent the compulsory education extends in that specific country, the child labor has to be prohibited. That is what very progressively it has incorporated under ILO article, the Convention 38 in 1973. That means in any country, if compulsory education extends up to 18 years, then child labor has to be prohibited up to 18 years. That is the mandate which is given under this ILO Convention of 38. So here, but it also said that in that particular convention, it is said that it has to be at any cost. It cannot be reduced below 15 years of age. But if the country provides facilities, adequate facilities, then in that case, it may be reduced to 14 years also. Compulsory education has extended up to 6 to 14 years under 45, which has been elevated to fundamental right, and which is also given statutory position under what you call this under Right to Education Act of 1990. So that is what, this in the case of if at all they are very much committed to implement this prohibition of child labor, right to education has to be properly implemented. So as students, you have to work in this direction, actually, to see that the free and compulsory education is implemented also in private sector scrupulously. And that should be one of our agenda in the campaigning, whatever campaigning programs you take, that should be one of the agenda. And you have to see that, this unless and until the civil society gets involved, such problems cannot be solved that easily. Only by initiation of the government initiations and the international convention and national convention specify it, it is not enough. We have to fight to see that these rights get sustained, these rights implemented, enforced properly. So that is it. In the case of child labor, this is what I thought that I have to discuss about. And when it comes to this, what you call this child abuse, child sexual abuse, that is right of protection from exploitation, abuse, and neglect. Neglect of the children, this, child abuse includes child neglect, treatment at home. The root causes are many, as I already informed that it is if the family, the poor, mostly poverty, illiteracy, and what you call this, not getting proper employment, proper means of livelihood, lack of proper means of livelihood to the most of these people, which drives the parents to, especially the what you call some of the people in the, they will be driven to drunkism and alcoholism, and this actually has led to a lot of what we call they'll be ill-treating, abandoning the children. They will be ill-treating the children at home. So that has led to they will be driven out of the house and they'll be forced to go for child labor. They will have some work or the other, they'll be forced to go for in rural areas, or they will be put as forced labor. They will be for clearing their debts, they will be living like that sometimes, in cities also, mostly in dabas and other places, hotels, and as domestic workers, domestic workers naturally, whether it is boy or the girls sexually abused, even for that matter, boys also, they get sexually abused. All these things will be, So this is, they will be child labor and the abuse sometimes, the child in all these places, that is at home. At home, by nearby neighbors, their own nearby what you call relatives, friends. So they are the studies reveal that actually child sexual abuse takes place mostly by the what you call your own friends, relatives, and nearby neighbors, especially. The best example is recently it happened in Andhra Pradesh. 6 years girl got actually sexually assaulted and killed by the neighbor. This particular incident has actually has evoked much what you call it has evoked certain debatable issues. In fact, the culprit, in fact, the culprit, they were all living in a rehabilitated center. These people were displaced from village because of some dams were actually in the place as a what you call this displaced from their villages, and they had to shift to the cities where this center is given. Very small rehabilitated center, a temporary center, in fact, a temporary center. Then like sheds, they put the sheds, and in that, they will. So one parents, they have come with two kids, kids in this girl 6 years of old. Then when the neighbor called her, that fellow, and he is under the influence of drugs. So he molested. No, just because this girl is calling uncle and all, this fellow, the parents also did not observe where she has gone. So this fellow has abused her, raped her, and in fact, he got afraid, and then immediately he just killed her, and then kept her in the house. And this incident has so much. This fellow, and afterwards he ran away. So this many political parties and all parties, whenever the incident happens, the social activists and everybody will come and they lose so much publicity and promise them, assure them so many things, and all these things happen. Actually, this comes under POCSO Act. POCSO Act, but just we POCSO Act, but just in Andhra Pradesh. You try to understand sexual abuse, child sexual abuse. Actually, it was when it was rampant, especially after Nirbhaya case. Nirbhaya case. It so happened they thought of bringing this POCSO Act as a rampant child abuse. And we know that POCSO Act actually, because till that time, Sakshi in Sakshi judgment also, Sakshi is one of the NGO organization, a very renowned NGO organization which looks into this child rights and all protection of the child rights and also other aspects, the protection of women and children and other activities. So this particular when it is, it already made a made certain proposals, because that time they were used or for that matter both non-penetrative assaults actually were not taken into consideration under the definition of rape, and that is why they wanted to extend this, and then they made certain reforms on the recommendation of the law commission. Actually, they have been, and this particular act has come into existence, and for different types of sexual assault and aggravated sexual assault like that, they have demarcated, and the punishments were given of 3 to 5, 7 to 5, up to life imprisonment. So non-penetrative and penetrative sexual assault, aggravated penetrative sexual assault, for that, it extended. In fact, it is actually, this is a little bit of what we can see that it is a progressive reform, the reform which has come into effect for the purpose of what you call suppress, protecting the children from sexual abuse. But like any other what's called protective legislation, this has also been, it is not being properly implemented. And in fact, in that particular case, it has to be been. And by actually in Andhra Pradesh, it's a peculiar wherein in spite of the existence of this POCSO Act, for their own political agenda, one girl was raped by 4 in Telangana state by 4 offending culprits, including one minor. I think in that one minor is also there. So as a response to this, the AP state actually has introduced one legislation which is known as DISA Act. Actually, it is Andhra Pradesh Criminal Law Amendment Act of 2019. This particular legislation actually to impose death penalty against sexual assault and death penalty in case of women and against women and children. It's aggravated form of sexual which might treat actually death of the persons and the heinous crimes like, like Nirbhaya, which happened in the, so here actually they have they said that they have they said that on the particular according to this particular legislation, so see that the offenses are the child abuse, child sexual assault against the children, especially under the 16 years of age and 12 years of age, you know, they try to demarcate it. And they said that, you know, if there is actually what you call substantial evidence, then in that case, the trial will take place and then the investigation will take place in 7 days, and 14 days the trial will take place, and within 21 days they will dispose of the case. So it was a criticized, you know, and death penalty was also included as an alternative here in heinous sexual assault against the women and children. So this was, police stations were also appointed. The already, you know, every police stations, a lot of money was actually apps. So these apps were, I mean, launched by the state government, and for publicity sake itself, crores of rupees were spent for this, you know. But after and this actually, this for the case of, because it is in a concurrent list, and actually this particular Amendment Act needs to be get the assent of the Parliament. So when it was sent there, till now it has not come. You know, they demanded these people that they have to do certain. It can come in the form of a procedural technicality. Some technical rectifications has to be made. Like that, they have sent it, not twice or thrice. Till now, it has not come into effect. But still, here, you know, everybody says that, you know, this act, actually, it is very ridiculous. The state, she announced that 3 persons were, and some 20 persons were sentenced to life imprisonment. Like that, she made an announcement. Actually, nothing has taken place like that. Nobody was actually prosecuted under this particular act. It is not possible because it has not come it is not come into effect at all. That is what is happening, you know, that is how the measures have been taken, the half-hearted measures just for the sake of publicity, and they just for their political agendas, you know, which will not be implemented. The existing enactments itself, they are not getting implemented, whereas this particular legislation, you try to understand why I specifically said, because most of you don't know about this situation in Andhra Pradesh, how this acted. Actually, they need not bring this enactment at all, because already Government of India under 2018 Criminal Law Amendment Act, actually death penalty was imposed as an alternative in the case of children under 16 years of age and 12 years of age in the gang rape cases. In gang rape cases, actually, it has imposed death penalty as an alternative, especially children under 12 years and under 16 years age. Between 12 and 16, actually, they will be given life imprisonment. So, when this particular act, central legislation is in existence, there is no going to discuss about anything about. I'm not here to criticize the government or whatever. But here, this particular legislation, in fact, you know, so, but already the Home Minister herself, she has made the statement. So how it is getting, all these reforms and legislation are getting implemented. My main concern is to see that how they are getting implemented, to what extent what you call the victims are getting protected, especially the children are getting protected. So here, this is what happened in the case of child abuse. The legislations which are there, the POCSO Act, the Amendment Acts, and the judiciary has intervened. Judiciary has given a lot of positive judgments. In fact, you know, a lot of directions have been given, but in actual practice, they are not being implemented. That is what is my concern. That is what the concerned citizens are worrying about. The student, especially the children, are not getting protected properly. This is one thing. What is the time? Oh, the next panel is question. As far as the freedom of expression and all, freedom of expression and freedom of movement and all other rights, which are our constitution empowers on all the citizens of India. These are also not. It is difficult for the children to exercise these rights. They will not freely express. For that matter, now after this pandemic situation, during this pandemic situation, even the elders are not able to exercise their freedom of expression, especially in our state and the Andhra state. Absolutely, there is no freedom. When they question about any of this, what you call this protective activity, I mean the government being distributed. They are, why they are not questioning of any face the rate of this, and they are being I mean, what you call under sedition law is being used against such persons in our state, and especially those who are questioning. So how about these children? They can't expect these children to express their feelings also. They can't come together and discuss. In their community also, it is very difficult for them to come together and discuss about their problems. And also, here, even the NGOs, whatever the NGOs are distributing, because I have a practical experience over in my place, in fact, whatever the NGOs, they are, most of the NGOs are doing very good job. But that is not being properly distributed. The middle persons and all, I have observed here in some of the slum areas, when we ourselves, when we have taken some of our organizations and when we are going, they say that they will distribute. It is not a state actually is not properly doing anything for the protection of these people. But whatever little that the NGOs are trying to extend, that also is not it is not properly being done because of what you call lack of commitment in the what you call the authorities who are responsible for the upbringing of the children in the education field and also in executive body and whatever it is, all these people, there's lack of what you call this commitment and accountability from the government or the monitoring system. All these things actually monitor all these things, that the National Commission on Children and National Commission on Women, they're not properly monitoring. They have almost ridiculous. I feel like that, whether it is in the case of sexual, the child abuse, or access to education facilities, or access to health facilities, or in any other form, they are not, whether the exercise of the leave alone, the rights perspective is not there, not at all there among the authorities or the, see, they always are the welfare, have that perspective at all. Always they think of the protectionist approach only. Family disintegration of family system, the divorces, and accordingly the parents also are putting that psychological stress of the children is more nowadays when this divorces are going increasing. That is also that I'm not denying about that, but they have to take the parents' problems and stresses and psychological stresses, and they are actually impacting the children to the maximum extent. So we are all, we should see that these are some of the areas where I thought that, proper focus must be made. It is not the, what you call the awareness program, that we have to participate. The students have to participate in seeing whatever the government, the programs or initiatives that are participate, and they get properly protected from all such what you call perpetrators of addressed by us, especially the civil society, and which includes also the student section. So that is what I, in brief, speech as such, non-academic, and they mostly based on the ground realities of. This is in brief because the next panelist might have come, So so I'll just try. We have all to get involved in the protection of the children, all sorts of the children, that is our, everybody, the civil society has to be cautious and monitor. The state is primarily responsible for the protection of the children, women and children especially. Thank you. Anybody who wish to?
Thank you, ma'am. Thank you so much. Damini, are there any questions?
Yes,
Thank you. Thank you so much for the wonderful session, ma'am. As of now, we don't have any question
Yes.
in the chat box. So
Yes.
I would like to arrive to the concluding part of this second session. Thank you
Yes.
so very much. On behalf of our Manikchandra Pahari Law College, we take this golden opportunity to thank our Chief Guest of Honor, Professor Dr. Nirmala Nadella ma'am and Professor Dr. Anisha Sheikh ma'am, who gave her vital time for her busy schedule to grace this meeting. We'll cultivate the admire you gave us in real, ma'am. I want to thank all the speakers for donning their necessary work and sharing with us graceful opinion. Last but not the least, thank you very much to all the attendees present here for passing attention and learning. And I also thanks to all the dignitaries for sparing their precious time for us and gracing the occasion with their presence. Thank you so very much. And now I would like my peer Govinda to take over the charges. Thank you so very much. Over to you, Govinda.
Okay. See, no questions, no one? Okay. Okay.
I hope I am audible, Aparna ma'am.
Yes.
Thank you, Damini. It gives me immense pleasure to extend to you a very warm welcome to the third session of online training program of child rights on behalf of Manikchand Pahade Law College. I, Govinda Zhalte, student of BA LLB third year at Manikchand Pahade Law College. In this session, our resource person will discuss educational aspect. Ma'am, am I audible?
Yes, you are audible.
Yes.
In this session, our resource person will discuss educational aspect and right to Free and Compulsory Education Act 2009 and child labor issues under Child Labor Prevention and Regulation Act. Today we are honored to have Dr. Sheetal Sharma ma'am, Associate Professor at JNU New Delhi, as a resource person for this session, and Professor Shivkanya Kadam ma'am, Professor of Law at Government Institute of Forensic Science, Nagpur, to introduce sub-theme of this session. I would request Professor Shivkanya Kadam ma'am to kindly introduce sub-theme of this session. Over to you, ma'am.
Thank you, Govind. Very good morning to all. The honorable guest speaker of present session, Dr. Sheetal Sharma ma'am, and the respected organizing team of Manikchand Pahade Law College, Aurangabad, and all the learned participants present over here. First of all, I would like to express my sincere gratitude to the principal, Dr. C.M. Rao sir, Vice Principal Professor Shri Kishan More sir, and especially Dr. Aparna Kottapalle ma'am for giving me such an opportunity to introduce the sub-theme of this national online training program on the topic, which is very interesting topic for me, that is the child rights. In this training program, people from various disciplines such as arts, science, commerce, law, etc., they have joined together. And hence, instead of focusing on any particular right or particular topic, the broad theme that has been chosen so as to provide orientation about the child rights to the participants. The present session, which is focusing upon the broad categories, that is right to education and right to protection from child labor. These are the two essential sub-themes of this particular session, which is conducted by Honorable Dr. Sheetal Sharma ma'am. And see, since morning we are listening and we are enriched with the knowledge from various legendaries on the topic, that is child rights. I am here to introduce the sub-theme. Before moving towards the sub-theme, I just remember one of the subhashit which I come across when I was child. That is Mata Shatru Pita Vairi Yena Balo na Pathitaha Na Shobhate Sabha Madhe Hansa Madhe Bako Yatha. That is, those parents are treated as enemies of that child who did not provide him education, and because why that particular thing is the person they are treated as enemies, as such child could not get respect in the society of the learned people if the child is not educated by their parents. So it made the important responsibility of the parents through this particular subhashit. And I today on this occasion I just click in my mind this particular subhashit, so I tried to narrate the theme through this particular subhashit. Along with that, that is right to education, which is provided to us by Indian Constitution under Article 21A of the by the 86th Amendment Act of. In addition to this, we are also having, or we are in need of, the right to free and compulsory education, which is guaranteed by right to free and compulsory 2009. So that is very much necessary to be provided for the overall development of a child. Along with that, the other right which is needed to be child, that is prohibition from child labor. Because if we are providing, because for the protection of human rights or promotion of human rights, promotion of rights, that is no doubt essential, but along with that, protection from exploitation, that is also necessary. And due to that reason, a very nice sub-theme that had been given by the organizers and which are included in a single theme, and which is given to a single speaker, that is Sheetal Sharma ma'am, that right to child, which is directly linked with, or which is having connection with protection from the child labor. So I will not take much time and so as to introduce, because many things that will be, or we will be enlightened on the particular topic, and will be discussed by respected speakers, Dr. Sheetal Sharma ma'am. So I just, without taking much time, I would like to mention one of the quote of Nelson Mandela, who is a Nobel Peace Prize winner, and also he worked in South Africa for protection of rights of the people there against the racial discrimination, that there can be no keener revelation of a society's soul than the way in which it treats its children. So thank you very much. Again, I am very thankful to the organizing team and all the participants present over here for listening me. Over to you, Govind. Thank you very much.
Thank you so much, ma'am, for introducing sub-theme of this session. I take this opportunity to introduce such an esteemed resource person for this session, Dr. Sheetal Sharma ma'am. Dr. Sheetal Sharma ma'am has completed MA and MPhil from School of Social Science, JNU. Dr. Sharma ma'am is PhD holder in Sociology from Center for the Study of Social System, School of Social Science, JNU, New Delhi. Ma'am has keen interest and over a period of time achieved specialization in research methodology, education and social development, gender and empowerment of women, culture and society in Europe. Ma'am has experience of working with School of International Studies and Center for European Studies as an assistant professor. With that, ma'am has worked as lecturer for Institute of Technology and Management at Gurgaon. Dr. Sharma ma'am is awarded and honored with JNU Excellence Award for outstanding contribution and excellence in field of social science and humanities. Recently, ma'am was selected for prestigious European Union Visit Program 2020. Ma'am is awarded consultancy project titled as Update of 2015 Perception Study by PPMI Group, UAB Europe, acting on behalf of European Commission. Along with that, ma'am has successfully played role of expert evaluator, consultant, subject matter expert, course coordinator in prestigious international collaborations. Note for all the attendees, if they have any question, query, they can post the same in chat box. As everyone, and also I am quite eager to hear ma'am. So without any further ado, I would request ma'am to begin with key speech. Over to you, ma'am.
Much. Thank you so much for inviting for this very lively and vibrant, I would say, workshop on human rights. Good morning to one and all, and I'm very keen to speak. In fact, as a teacher, we always have a disease to speak, so you can't keep teachers quiet for a long period of time. And why I just acted like this to cut short my introduction, because my speech is going to be my introduction, no matter how many laurels you read about myself. But something which I'm going to do in the next 1 hour with you guys is actually my introduction, that how much am I going to deliver what I intend to speak on human rights, rights of children, education, and child labor. Now, I have a PowerPoint presentation here, a short presentation for you people, so that I keep you engaged here on screen also, because online teaching has its own demerits and merits as well. Now, I'm a sociologist, basically, and I'm going to speak on the subject and offer you a sociological perspective, that how do we look at the idea of human rights in general and about children and child labor, or education of children and child labor from a sociological perspective, and how these things have evolved over a period of time, and how do we analyze sociologically, what is there for us to take out, what are the sociological lessons to learn from it. And that is where I'm going to touch upon the interdisciplinary aspect of the topic under lens. And since I'm told that most of you are also research scholars, those who are doing your PhD or are engaged in law study, and also some of the professors, I will also have some methodological lessons in between, that how do we look at sociological aspects of law, human rights, education, and child labor. So how am I going to treat this in another 45 minutes, because 20 minutes have already been taken. Now, we are going to understand human rights, which the ground has already been set by the two previous speakers. I'll talk about right to education, child labor, and then causes, consequences, and a kind of sociological analysis. So this is how we start. Now, if I talk to you about the human rights and why I'm doing a bit fast, you might feel ma'am is going a bit faster because I have to cover a lot of ground, but I'll come on comfortably when I start actually talking about the sociological perspective or social aspects or dimensions of human rights. Now, in this particular slide, you see that when we talk about human rights, and Banerjee sir laid out very nicely about why human rights, why not rights of man or rights of women or individual. Human encompasses, it's a very big, all-comprehensive umbrella which almost covers every soul on earth, irrespective of whatever you talk about. Irrespective of any of the social, political, economic, regional, geographical dimension, language, whatever you may say, human tends to cover every live soul. And by live soul, I mean the person whose heart is beating, no matter he is in coma for 20 years. So this is actually about human right. And very interestingly, the right of a man or right of a human begins, if I may use it like a man, but not an offense to other genders and all. But when we talk about human and the soul, the right of an individual or right of a human being begins at the time your heart starts beating, even if you are not a born child or you are unborn. Say, for instance, when you are in womb, unfortunately, if some calamity happens, you still retain your right to your property. because you are part of that legacy or you are part of that family. So it is inherent to every soul which is live, where heart is beating, irrespective and without any discrimination and entitlement. And these are interdependent and indivisible. Now, when I say the last two things, without discrimination, interdependent and indivisible, these come because we human beings are related to one another. If I speak or I do something all for myself, it's an action. Say, for example, my breathing is an action, my viewing is an action, everything that I do for myself is an action. The moment I do some action vis-a-vis the other individual gets involved, and this becomes a social action. Because both the meaning, intent, content, causes, and consequences of my action are going to have an implication upon the life or the thought process of the other individual. And this becomes a social interaction, social action. And during these social actions or interactions, we tend to identify that it's not a human interacting with a human. Because we are part of this society, because we are part of this social system, there are large number of visible and invisible actors and factors playing an important role. And this is where we need to understand that we talk about entitlement without discrimination. It is second point that you see because of sex, nationality, ethnic origin, color, religion, language. These are all criterias, these are all factors, and some of them are actors that tend to keep me away, alienate me from my entitlements. So when we talk about human rights, we talk about equal entitlement without any discrimination, because this discrimination is rooted in something which is mentioned in point number 2. And then these are all interdependent. Why we say interdependent? Because one aspect of social life is related to another. When in social sciences, I was talking about making a concept map. So when we talk about 3 broad pillars, society, economy, and politics, all 3 are related to one another. And then there are sub areas, education, law, languages, institutions, judiciary, everything gets connected to all these 3 things. And then there is an interplay. There is an interplay of change in one leading to changes in another. And that is why they are interdependent and indivisible. ये नहीं हो सकता कि मैंने खाया तुम्हारा पेट भरा. This is not applicable to human rights. So this is very important that they are indivisible. Now, coming on to the other aspects of human rights, that when we graduate above the level of individual existence, a soul, a breathing soul, we come into societies, and as societies take a formal shape, there is evolution of some structures that guarantee this. If I ask you to imagine a society which did not have these formal institutions, certain nomadic, primitive, barbarian, any kind of society you can imagine, depending upon your length of imagination back into the history. Now, when we talk about those societies, those times, those areas, the rights were even existing at that point of time. But who would guarantee those rights? Who would guarantee those rights? Who would talk about that, okay, one individual rights are not being violated at the cost of the privilege of the other individual? But modern societies have seen evolution, gradual evolution and formalization of this idea of universal human rights. And these are guaranteed by law. Why I would talk about some points of history where this formalization, this institutionalization has happened. But interestingly, there are cases even in the mythology, or even if you talk about ancient India, or some interesting stories existing in Upanishad, particularly Kathopanishad, when we talk about that, who guarantees these, because human rights were always there. So these are guaranteed by laws which are compiled in terms of some treaties, international law, general principles, directive principles, whatever, state policies, whatever you call them, by whatever name, but their intent and content is to guarantee human rights and principle of non-discrimination applied to every individual. And then governments have certain mechanisms like check and balances, what we talk about Indian political system, and a system which has 3 prime organs of legislation, administration, or executive and judiciary. These various organs act in coordination with one another, at the same time independently, in order to refrain certain acts or to protect or promote human rights of individuals. So together, our political machinery is devoting its time and energy to maintain what is expected out of the state machinery or in the statecraft, and what is my right as. So rights and duties of every individual organization institution is interrelated to one another, and that is how the whole system functions smoothly. And this is the crux, that how sociology of law actually look at the social system to understand that how various parts of this social, political, legal system are coordinating with one another to actually do something. Say, for instance, if imagine your human body. We don't consciously feel that I'm looking at something, my eyes are functioning. At the same time, I'm talking to you so fast, want to deliver so much, but breathing is going so naturally. It's the bodies are like the societies. Every part is playing its appropriate function in coordination with one another. That's the functionalist perspective. And at the same time, it's delivering what is supposed to be, and it's maintaining the whole. The totality is maintained as a consequence of individual parts performing their function in relation to one another. So that's what is nation. That's what is society. That's what the individual functions are being happening, and we contribute to the whole. So what are in general some of the identifiable features? Universal, inalienable, interdependent, indivisible, equal and non-discriminatory, rights, although of course rights are there, but then they are hand in glove with duties or obligations. And one individual's duties not rightly performed is a violation of somebody's right. Say, for example, I'm going to talk about right to education. Right to education kiska hai? Child ka hai. Child has a right to education, right to get educated. We time and again emphasize upon quality education. But that right is actually associated with my duty to discharge education or impart education, quality education. You may add as many adjectives as possible to this, but his right is dependent upon my duty. And if I do not perform my duty properly, I am infringing or violating somebody's right to have quality education. So that is how the interdependence is identified, and rights do not just exist in abstraction. They are in context, they are related to others, and also to the whole lot of set of duties and obligation of the other individual in this whole gamut called as social action. So this is both rights and obligations, and then inspiration and empowerment. That is how they actually empower an individual, create conducive environment for realization of your potential, and actually become an active member, or if not active, at least a member of the mainstream society. That depends later upon the performance of the individual or his ability to contribute towards the whole, but then actually part of the mainstream society. And this becoming part of the mainstream society is such a big debate that people say that, these people have to be brought into the mainstream. They are marginalized, they are discriminated, they are in terms of regional discrimination, marginal discrimination, whatever. So we use it casually sometimes, being part of the mainstream, but being part of the mainstream itself is a whole lot of debate, which actually is a step to counter the kind of discriminatory practices, or intended or unintended, which are defining the narrative, the discourse, the actual operation or unfolding of lot many social, political, and economic processes. So coming on to right of education. Right of education, I want to give you a sociological perspective. Now, what do we mean by a sociological perspective? And this is a research methodology lesson for all my listeners out there. How do we make sense of social? How do I understand that this is social and I have a sociological perspective? Say, for example, I'm a teacher, and many of you are teachers out there. To a teacher, the easily available prop in the class is this duster. Can you see my duster? Yes, it's visible. Now, duster is something which is the piece of reality. And now I'll tell you what is a perspective. What happens when we look at this duster is three-dimensional. But depending on our vantage point, we tend to see only one or two dimensions of this duster, because it's not possible for me to rotate 360 degrees to this. And unfortunately, or as a limitation of our perspective, sometimes we tend to see our perspective and consider this to be the entirety. Consider this to be the whole, although we are just looking at a narrow dimension of this whole reality called as duster. So for you, this is soft because I used to rub it this side. This is a different perspective for you. For the others, those who are on that side of the reality, this is hard. So this is a different perspective for you. For some, it's slim. For some, it's further down, small in size. For some, it's so big, but the reality remains that it is in totality. And depending on our vantage point, we tend to have a narrow perspective and tend to consider this is the perspective. And that is why you have ideological differences. That is why you have standpoint differences. That is why you have various perspectives. And how do we make sense of these perspectives? There are a couple of theories in social sciences or in all social sciences that tend to look at the world from different perspectives. I'll discuss some of them, but before that, let's come on to the understanding of evolution of education. And then I'll tell you certain sociological perspective on education itself. As we see, education was always there, always there. Otherwise, we would have not reached up to this stage in our life or in humanity. Even if you don't guarantee modernity, digitalization, space, rockets, all these things, no understanding about our Milky Way and all that, education would have been there, but it would have acquired a different kind of form. Say, for example, just skill-based education or skills required for the survival. But when we see evolution of society, and I would take particularly a point of time in history, particularly from European history. Don't think about why I'm taking European history, because much of the writings of the modern discipline, formal disciplines, they have their roots in Enlightenment era in Europe. So that is why we tend to take sometimes a benchmark era from where we see a paradigm shift. Now, all great journeys, as we say, begin with small steps. All big ideas come with very small ideas, thinking otherwise, that why this apple is falling down, why not going up? Okay, or what could be the reason behind something? Traditional knowledge was theological in nature. No matter whichever region or whichever religion you pick up, the content of the knowledge was primarily traditional and theological. Yes, of course, there were elements of other sciences as well. Say, for example, our knowledge tradition was so rich. Ayurveda and about way of life, about living, about health, about conditions, about surgery, all these things were there. About nyaya, jo bahut detail mein hai, niti gyan, raj dharma, and all these things were there. But primarily, this was all woven into a form of traditional knowledge. As societies evolved, law also evolved, education also evolved. And then we see suddenly in the last 400 years, what is the state of affairs now, what we call as modern societies. We see that there was a shift from tradition and modern societies came into existence. Modern societies, what happened? When modernity was established in this era, there was a paradigm shift, and this paradigm was scientific in nature. Now, what was scientific in this modernity? Science was that it attempted to measure everything. How do we measure? Because earlier, time, distance, weight, everything was on the basis of some arbitrary scales. But as science stepped in, and this is the work of scientists of that era, some 500, 600 years, the other things, you may counter, ma'am, these were things, these were there, these were there. I would say, yes, of course, I accept they were there, but they were discretely located and they were only isolated instances of knowledge and scholarship existing, not related to one another and not at the level of mass consumption or mass production scale. Now, modernity had a different rotating mechanism. Iska engine jo tha na, wo thoda powerful tha in the sense that it spread all over the world very quickly. And it engulfed large number of people. It wasn't a coterie of small number of people kept as privileged class and rest of the people as followers. No, it was an equalizing force. Although, of course, it led to greater inequalities of different type, but to begin with, to understand that it was an equalizing force, and in modernity, people started having scales of measurement: time, weight, energy, motion, temperature, this. And the same got applied to society also. So people started developing laws of society. Laws of society in what sense? Suppose I say that I have to understand development in society. So what I will say, I will just take this board. I'm missing classroom teaching, but I'm not leaving any instance for that. If A is education, you can see my board. Yes, A is education. it's directly proportional to B, income, which is indirectly proportional to C, crime. This is a law-like explanation of society. So people started doing this. The same got applied to political science, that if monarch is not ruling us, who would rule us, how would rule us, what will be the rules, what would be the codes, who will govern, how will govern, for how long they will govern, how will we choose them, how will we elect them? Procedures came into existence, and then law got codified. In Europe, we talk of such ghastly laws, such inhuman treatment of criminals and all that. But as this codification, this measurement started, there was emergence of crime and corresponding set of punishments. So codes, civil, criminal, and all these things started coming into existence. कि छोटा सा crime hai, it's not upon whims and fancies of the king or the monarch that, okay, you're close to me, so you're let off even if you kill 10 people. And if you're not close to me, you're a commoner, then even if you steal a goat, you must be given a capital punishment. No, absolutely not. This is no longer whims and fancy of one individual. This is going to be something which is codified, universally applicable, scientific in nature, and there is proportionate crime and punishment. So there is codification of law, and then there were branches and branches in it. This is called as institutionalization of an activity, even if it is education, if it is law, it is politics, whatever. Institutionalization happened. And this institutionalization actually can be also seen as a consequence of some of the fundamentals of era of enlightenment. And one important was the French Revolution, one benchmark event in history. And French Revolution, although changed the way we were looking at the world. Monarchy gone, democracy in, although of course Napoleon came back, but that was a very failed experiment of bringing back monarchy or conservatism. So French Revolution comes, democracy comes, modernization comes, science comes, your urbanization, commercialization, mechanization, everything comes one after another, and the sum total, the resultant is that there is objectification of world. Now, what is this objectification? This objectification is not the object, but objectivity. If objectification is objectionable, then you can say that the subjectivity from the world was eliminated, uprooted. जैसे हम weed निकाल देते ना, unweed करके we brought in objectivity. And what is objectivity? अभी मैं आपको एक simple experiment बोलती हूँ करने के लिए, and just imagine as I say. I'll say few words to you, and I'll ask you to imagine, and we'll establish that what is the difference between subjectivity and objectivity. If I ask you to imagine a flower, all of you, please imagine a flower in your mind quickly. If I asked you to imagine a fort, depending upon your location, your culture, your rootedness, you can imagine image of a fort. हो रही है सबको? I'm assuming हो ही रही होगी. Even anyone can say yes to it, or you can raise hand in your chat box and all. So imagine a fort. Imagine a field. Imagine a temple. Okay. Now let us come on to the focused area. Imagine a king. Depending upon your location where you are rooted, if you are in a tribe or you're in a modern society or in a conservative society, imagine a king and an image comes to your mind. And when I say that the primitive or the previous traditional forms of societies were ruled by kings, an image comes to my mind. And below king were the people, those who are called as subjects. And if I say, imagine a subject, something comes to your mind. A person who is follower, a person who is, lean, who is actually exploited, subjected, exploited, whatever you can say. The modernity, the French Revolution, it replaced this equation between the king and the subject with something different. And now when I say the word, please try to imagine a picture or an image. The king was replaced by state. Now imagine image of a state. It's not as crisp as image of a king is. Somebody may see a map, somebody may see a globe, somebody may see your state only, somebody may see a Vidhan Sabha or a parliament. There is no clarity about. हमारा जो subjective rootedness था ना, वो खत्म हो गया. हम objectively सोचने लग गए क्योंकि उसमें हमने कोई भी irrespective of caste, sex, dictator, सब निकाल दिया. So the king was replaced by state and the subject was replaced by citizen. Now imagine image of a citizen, difficult to imagine. You can imagine an individual, you can imagine R.K. Lakshman ka common man, you can imagine me, you can imagine yourself, you can imagine a lady, a gent, whatever. But the image which were very clear and crisp, subjectively rooted here, are not so clear here. So the sum total is from subjectivity, we move on to objectivity, and that's the beauty of this transition from science to modernity, from tradition to modernity in science, that it eliminates anything which is rooted in your cultural moorings, in your cultural rootings. And along with that, differentiation happened, specialization started to happen even in law, in education, in engineering, and disciplinary boundaries started to emerge. And the function of education also underwent transformation, that education is no longer restricted to theological understanding or knowing what God has ordained us, but education is knowing my cornea. Ki agar ye kharab ho gaya, if she has kala motia, how do I operate, which has got nothing to do with God or anybody else. So function of education got transformed. And there were differences between the formal and substantive aspects of life and living. These were the things which were very interesting, and I bring you down to the functionalist perspective now. A bit quickly because I have to finish by, yes, another 20 minutes. Aparna, 20 minutes is too short a time to cover so much, but then let me try my best. Wherever I end, I'll just end there. Now, functionalist perspective, you remember this duster? This duster was, ab hum functionalist perspective ko dekhte hain. Suppose this is functionalist perspective. Functionalist perspective says that education serves certain functions of socialization, integration, placement, and cultural innovation. And it also performs certain latent functions, which are giving a kind of, socialization between peer relationship, unemployment ko kam karta hai. We are trying to understand discipline and expectation, the baggage of expectation, roles, responsibility, obligation, duties, not just. And this is what is being discussed in contemporary times, that what kids are missing in online learning, and that is what is very important, that offline learning gives them a sense of responsibility, peer friendship, learning, competition. The world is too harsh. They learn the tricks of trade. They learn about the hardships of life, which sitting in your comfortable room with your rajai on your lap, you can't understand. You just can't have this. Even, getting dhakkas in the bus is also a lesson which kids are missing by not using a public transport these days. So there are latent functions that education performs. At the same times, there are things which are being missed, but generally their perspective is only upon the contribution that education makes to sustain the societies, just sustain the society. The next perspective is conflict. A conflict perspective is opposite to functional perspective, and it says education promotes social inequality and asymmetry. अब ये कैसे होता है? There are examples even in our great epics. For example, Karna was denied. Karn महाभारत में याद है आपको? कर्ण को एंट्री मना किया था वहां पे because he was son of a charioteer, एक रथी का सन था. तो they said कि नहीं, this education, this ashram is only for prince and their families, so you are denied entry here. एकलव्य को भी एंट्री मना कर दिया था, तो एकलव्य went online. He had a figure of द्रोणाचार्य and then he learned it. और उसमें एक इंटरेस्टिंग, मैं आपको अपना इंटरप्रिटेशन बताती हूँ कि हाउ एकलव्य को हम कभी कभी कहते हैं कि उसका अंगूठा काटा, and there are various interpretations of it, and one of the interpretation which comes from my side, I think this angutha katna is symbolic of the lack of skill that you are getting online. Abhi, I was just telling you that much is left unlearned in the online mode, because even those dhakkas are very important to make you a strong man or a woman for the future world. Now, Eklavya did everything to understand archery because he said, Guruji ne mujhe teer marna sikhana hai. So Eklavya was learning everything. But then, क्या तीर मारना ही is totally a learning package? Like just covering the syllabus is the entirety what we learn. What he missed was कि तीर कब चलाना है, क्यों चलाना है, किस पे चलाना है और किस पे नहीं चलाना है. These were the things he missed because he did not interact directly with the guru. तो जैसे आजकल बच्चे are not interacting directly with the guru, they do not learn from his acharan, that is his behavior, that is his conduct. What they are learning is only syllabus here. So what is this अंगूठा काटना means? कि वो कुछ सीख नहीं पाया, कुछ समझ नहीं पाया. This is a symbolism of that missed points in the online learning. And this is where we see that asymmetry gets perpetuated from the conflict perspective. Kids are inquisitive, they want to know. And you another example I give you from Indian Kathopanishad I was talking about, कि नचिकेता पीछे ही पड़ गया पिताजी के कि मुझे किसको दोगे. If you have this if you have idea about this particular episode, so Nachiketa's father was donating cows and he saw that he was donating all frail and muriel cows. So he said कि why are you doing this? तो पूछा कि मुझे किसको दोगे, तो he said कि तुझे मैं यम को दूंगा. So he went to Yam and started asking, and he did not come back unless he was satisfied with the answers. The similar story is with Dhruv. Dhruv was denied his right. Dhruv was denied his right to sit in father's lap by Suruchi Mata. So he said that कि मैं भगवान से पूछूंगा कि मुझे क्यों मना किया गया. And then Bhagwan himself came down, descended down Vishnu, and he said, I gave you the right. So he explained and gave him the position of North Star. Amazing stories. What are these? These are parables. These are the lessons from the history to know, to explore, to identify that kids are inquisitive. They are also aware of their rights, and this must to be understood in totality. So these are the lessons that we draw, not just from the formal form of education and institutionalization, but throughout the history we have been seeing this. But we hardly seldom take any substantive lessons from these. What we talk about is the formal upar ka bird's eye view of various things, and then we go back to the modern books, modern constitution, modern articles, modern clauses, forgetting that the rich repository of knowledge is existing also there. Coming back to this, conflict looks at this asymmetry. Asymmetry where there are differences in which even private, public, English medium, Hindi medium, EWS category, yes. Now you remember Krishna went to Sandipan Rishi's ashram and he was having a Sudama, a Garib Dost, EWS category. So Sudama had a kind of, very different kind of relationship. But then Krishna's behavior towards Sudama tends to show that despite the fact that you come from a economically weaker section, whatever category, there has to be a good relationship between, because you both are part of the same system where you are being taught by the same guru. So these are the lessons which are there inherent, but we sometimes close our eyes and tend to see only from a very different perspective, a religious lens, and hence we don't have to derive any lesson. It's because it's Bhagwan ka hai, hame wo karna hai. But these are rich repositories, and please in future try to interpret them sociologically and they'll be useful for us. Coming to symbolic interactionism, another perspective, that is how do you create knowledge, how do you understand, and then how these social interactions actually tend to create a world and how they are created. That is how the reality is created. I'm going a bit faster now because only 10 minutes are left. So what is RTE, right to education? And why do we need right to education? One, it is empowering. Second, it is lifting people out of marginalization and out of poverty. It is indispensable means, of realizing other rights. That is, if you are educated, you are out of poverty. If you are out of poverty, you get employment. If you get employment, if you are getting employment out of poverty, if you are out of poverty, you are aspiring a higher life. This. So related to realizing other rights, and it contributes to the development of human personality, consequently society, then in the long term, nation building. This is why a fundamental right to education is important, because as somebody was saying, Nelson Mandela said the way you treat your children is an indication of your societal values. And we say that this is one of the most important weapon to rewrite history or to write the course of future course of nation. That is why it contributes to not just human development, social development, national development, and then the global development. Now, coming on to the meaningful realization of education, it requires 4 A's. A for available, A for accessible, A for acceptable, and A for adaptable. Now, when I say these 4 A's, in order to have a meaningful right to education, we have to have, or we have to guarantee these 4A: available, accessible, acceptable, and adaptable, which is the sum total of the package of education. It's not just, and as I was telling you earlier, that somebody's right to education is also my great duty to impart education. So the interrelationship between rights and obligation, rights and duties, and making all this available as an enabling environment for the people out there is very important in order to realize the actual substantial meaning of. Otherwise we would just be floating in the numbers कि इतना enrollment हो गया, इतना वो हो गया, इतना drop out कम हो गया, इतना midday meal scheme दे दिया. This is not actual substantive realization of education. Yes, of course, this is important. I'm not saying that this is not important. This is the first stepping stone towards achieving the substantial goal. But more than just achieving the formal goal, the substantive aspect is why it is important, because we are a big society. Had it been a Nordic country where the total population is population of 1/10 of Delhi, 10 lakh है कहीं पे 15 lakh है, किसी का 50 lakh है. This is Dwarka, there's a sub-city in Delhi. Dwarka is 50 lakh people as compared to 4 countries of Nordic country. So it is okay to achieve even formal to substantive अपने आप corollary, natural corollary होता है. But when we are as big as society, 1.35 billion people, when we are such a big society, such a diverse society, we have to take care of not just the formal aspects, that's there for some people, but those who have gone beyond a threshold, because here on a line of development, on a timeline, on a scale of development, you have large chunks of population at different stations. So for every community or for every chunk of people, community is a wrong word here, for every group of people here, you have to have a strategy कि चलो ये formal तक आए, जो formal तक आ गए उनको substantive तक लेके जाएं, so substantive तक आ गए उसका formal realization हो. So you have to have a continuously evolving strategy for these kind of people, because our queue is too long, the weight is too heavy, the diversity is too much. So we have to have a continuously running process. We cannot just afford to switch off one engine out of 4. In fact, we need to have more than that, because we have to have a faster pace if we need to catch up with the developed civilizations or developed countries here. Now, this was introduced, this is all about history, and I don't want to, because you can always read it from any place, but then this was 2009, right to education, and this declaration came with it, all children should be able to attend school full time, have access to same quality education, teacher, student teacher ratio. These are the dynamics. Ye jo hai, this is the text of the act. This is the text of the act. So मैं इसको जल्दी आगे लेके जाऊंगी आपके साथ. But it's not, no detention policy was an important point. So this was taken back, because then this also had a kind of negative impact upon the morale and motivation of the students. So this was this. So it prohibits right to education. It prohibits physical punishment, mental harassment, screening, this, and it's focusing upon making child free of trauma, this, and all these things. Now, one important and achievements were these: enrollment बढ़ गया, class 6 to 8 successfully increased enrollment, and the quantitative indicators are good. Quantitative indicators are there to make you happy. Oh, we have achieved something through right to education. Achievements, once again, what government did from its side: Samagra Shiksha Abhiyan chalaya, Sarva Shiksha diya, RMSA, Madhyamik Shiksha Abhiyan shuru kiya, and all these things. And then challenges. Now, challenges I want to discuss with you particularly because वो सारा text था. You can find it पूरा 60 page का document है. You can read it yourself. Now, challenges क्या थे? Number one, no detention policy, and I am a witness of that. One padosi of mine, since there was no detention policy, and this is a first-hand account. First-hand account as a sociologist. बच्चे को दिन भर पढ़ो अरे फेल तो होना नहीं है. And this was later on. There's a very interesting study by KPMG. You can have a look at it. It's also downloadable about KPMG and outcomes of right to education. The organization has done a detailed study, and they have mentioned a lot about no detention policy. Then how this was actually a deterrent in terms of realizing the substantial goals of right to education. कि school जा रहे हैं, fail नहीं होना है, and those kind of things. That's why it was withdrawn. And even the teaching community, I was part of communities which are involved in school education because I work a lot for NCRT also, NCRT in terms of school education. So teachers were unhappy. They said, ma'am, this is leading to demotivation rather than motivation. And this is where disciplinary issues and lack of motivation, the second point which I mentioned here. And then with EWS and all that, there were issues related to inferiority complex among students because of the difference private school, public school, and even among private schools, there were issues related to, say for example, issues related to what do you wear, what do you eat in the canteen, do you speak English at home? Some people are very frequent, some people are very fluent, and yeah, this culture. Have you seen Godzilla? Have you seen this movie? And the other one is watching regional movies or Hindi movies and all that. So there were issues related to this. These are substantial challenges of having EWS category. But we tend to look at upar ka view. Nobody realizes from a social constructivist perspective, ek meri atmakatha, meri kahani. If I belong to that marginalized, discriminated section of the society, how do I feel myself? Maybe, this brings me back to that modern or science ka paradigm, that we tend to look at the world from a very macro perspective. Ki mota mota ye ho gaya. We do not look at the world from a smaller perspective. Say, for example, I bring this movie, the Zameen, Tare Zameen Pe. Tare Zameen Pe talks about a school system, schooling system. Everybody fits into this checkbox. Tick, 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 tick. Class ho gaya, syllabus ho gaya, tennis khel liya, kar liya. Ek bacha who does not fit. So nobody is looking at him. So this is a methodological lesson for parents. That movie is not for kids. That movie is for parents. In fact, parents, we the generation. कि बच्चे को इधर से देखो. It's a bottom-up approach. It's not top-down approach. Principal, class teacher, other students. It's a bottom-up approach. One individual having different set of abilities, and then how do you see? How do you bring up? But then once again, had it been a Nordic society, less population, it would have been easy that every Darshil Safari gets a Amir Khan. But in our society where people-teacher ratio is so high, it's very difficult. But nevertheless, good lessons learned. Wherever you get a chance, please act like that. Number 3, that we have to keep pace with the changing technology, and digital divide has become so quite visible, stark visible here. And even in digital divide, all through I'm discussing whatever, remember gender. जेंडर तो इनहेरेंट है. घर में एक लैपटॉप है, लड़का यूज करेगा. घर में एक स्कूटी है, लड़का जाएगा. घर में एक साइकिल है, भाई को चलाने दे. And I bring this example from Maharashtra only. Satara district में there were 265 girls with the name Nakoshi. And you know what Nakoshi means. And then the district medical officer by the name of some Bhagwan something, he identified, and with the help of DM and all these people, they changed their names from Nakoshi to something else, and they, in a mega ceremony, they gifted them the name changing certificates. Why Nakoshi? It's not about education, even it's not about labor, it's about the very existence, the label, the very existence of a girl. I have no time to discuss about gender right now, but my dear friends, it's inherent in it. And this digital divide, what I talk about, education, primary, secondary, EWS, whatever, there are double the there is a double the discrimination of gender, which is inherent in any inalienable part of it. And that is why I say that when this technology was there were issues that, ma'am, we have just one, and my brother takes it. Because brother is obviously a source, he invites investment. Like हमारी country में foreign direct investment ज़्यादा था, तो family में the boy invites investment, because उसमें करेंगे invest तो only we will get benefit. Girl में करेंगे तो all this. These are nothing new. I'm not giving you rocket science, but this is there. Then there were non-timely payments by state governments. And इधर ही issues दिल्ली में तो होता ही रहता है. MCD schools don't get payments. Teachers are not paid for weeks and months. And then in the process, what sometimes we derive pleasure from is the quantity rather than the quality. Yes, of course, in a big society like ours, there are issues where sometimes we have to find solace in quantity. Sometimes we have to criticize only quantity and talk about quality. Sometimes we have to find solace in quality. Sometimes, ये एक वो black and white situation नहीं है, there are shades of gray. But then primarily it should not just remain on quantity without any substantial outcome or output. So input output there has to be a balance. And then there was increasing pressure upon teachers. And all of us are from teaching fraternity, and then on Teachers Day you get very lovely messages, the best individual, this you have made my life, this and how horrible you make life of teachers also. Sometimes it really needs to be taken into account, administrative task, financial, this along with personal and all these things. It's a pressure, increasing pressure upon teachers to keep this. And once again, during Corona, everything came to stop and teaching went into 6th gear, 7th gear. टीचिंग तो हो ही रही है, पूरा मोड इज शिफ्टेड. जैसे कार्ल मार्क्स का नहीं है मोड, फ्रॉम एग्रीकल्चर इट वेंट ऑन टू इंडस्ट्रियल, यहाँ पे ऑफलाइन से एकदम से ऑनलाइन हो गया. देयर वाज अ होल लॉट ऑफ लर्निंग. हमारे मतलब शुरू में तो बिल्कुल ऐसा हेयर स्क्रैचिंग काइंड ऑफ कंडीशन वाज देयर दैट हाउ डू वी मैनेज टीचिंग. बट समहाउ क्लैप्स टू एवरी टीचर आउट देयर, माय सैल्यूट फ्रॉम द राइट फ्रॉम केजी अप until PhD, that how we have managed to keep, survive, sustain the profession of teaching and the teaching entire thing. So these are the things which are there. Now, lack of qualified and trained teacher, do not think that teachers are unqualified or untrained. Teachers are there, but most of the quality of teaching is dependent upon many other factors. Say for example, availability of this this medium of communication only. Ab mera network katta rahega, you would not be able to find it interesting until it goes swiftly. So there is it's not lack of qualification in the teacher, it is the support staff, it is the supporting mechanism, it is the supporting objects and subjects and digits and gadgets which make it easy. And now if I start telling you, there is a state called as Germany. Germany got divided into two, East and West Germany, and then the capital of West Germany was Berlin. Berlin was divided into 4 sectors. ये क्या बोले जा रही है? And if I have a map, aiding material, audio visual, so quality comes with many other things. It's not just about what is there. Yes, of course, sometimes you have to sing even without music playing behind. But then most of the time, the teaching has to be of quality. And that is why if it's not recognized in European countries, the highest paid profession is teaching. In Western countries, in US, teachers don't retire. They die in their office. They retain their chambers. यहाँ पे तो लफड़ा ही चलता रहता है, न्यू पेंशन स्कीम, ओल्ड पेंशन स्कीम, दिस स्कीम, दैट स्कीम, which retirement age, 58, 62, 65. There are a whole lot of things there. After all, Baba, we are individuals. We are also surviving in the world, and we are, although of course it's a vocation, it's a profession. My passion is teaching, but ultimately I also have a family at the end of the day. So this is what we have to see, that how do we attract the talent in order to make teaching effective. That is, when I speak, at least 10 people get influenced by it and attracted by it. Yes, one day I have to do like this. And that should be. And the teachers need to be energetic. Teacher, because my energy gets multiplied by as many audience. And if I'm, yes, we look, RTI says this, and this was the year, that was the, blah, blah, please, you can read it better than me if you have good English or Hindi or whatever. So it's please remember, all the teachers here and the future teachers, always remember that your energy is getting multiplied in this cosmos, and that is how it is going to be effective. Otherwise, it's going to be it's a money and time wasted. I know I'm exceeding 12 o'clock. I haven't covered much, but then there were too many things. But let me come on quickly to consequences, because there's not much time. Similarly, is with the issue of child labor. Child labor, I don't want to eat into time of somebody next in the queue. So consequences also about the child labor, that's the same problem. It is associated with poverty, societal norms. It is associated with the kind of system that we have, lack of proper avenues of employment. Even in child labor, you see the difference between gendered division of labor, in that कि child labor हम देखते हैं, उसी को देखते हैं, the person who is going out and working. अब घर में लड़की का तो चाइल्ड लेबर बचपन से शुरू हो जाता है, when she is helping mother and cleaning and cutting this and that. अब उसको चाइल्ड लेबर नहीं कहोगे, ठीक है, अगर उसको इफ चाइल्ड लेबर आप यू कैन कंटेस्ट कि मैम वो चाइल्ड लेबर कैसे हो गया, हाउ विल यू ट्रेन योर डॉटर टू बिकम अ गुड हाउसवाइफ आल्सो, सो देन यू ट्रेन योर सन आल्सो टू बिकम अ गुड मैकेनिक, तो उसको भी 8 साल से नट बोल्ट टाइट करना सिखाओ, if you want to perpetuate gender. These are very, 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 very big. They are vaster than, I would say, cosmos. So these issues can be taken upon case to case basis also, and they can be taken in totality. वो हमारा methodological lesson हम बाद में सीखेंगे कि macro approach लेना है कि micro approach लेना है. But consequence of all these discrimination and practices are physiological in the short term, psychological in the medium and long term, and social and national in the longest term. Because if your seed is healthy, you will have a healthy crop. If your children are healthy mentally and physically, you have a healthy nation. Healthy nation banega jabi. But if you start exploiting, unka aata gundna abhi se shuru kar do, it's very, we are producing, we have a very problematic Indian system because we are not a cooperative society, we are a competitive society because of scarcity of resources. Obvious hai. So what we do, the moment a star cricket Portuguese begins to sab apne bacche ko balla deke they send to cricket. अब वो नीरज चोपड़ा आ गया तो everybody is giving a bhala to send this. We are like sitting on a मूषक. We tend to go here and there कि हमारे shifting goal post हैं. भाई बनने दो, रुक जाओ, let take some time, have some patience. वो लाइन में खड़े होके ऐसे jittery. We don't have that patience to wait for time. Give time some time. Everything will happen. We have to understand that we are in a process of building something big. ये छोटा pack of cards नहीं बनाना है कि 1 मिनट में बन गया, फू मारा 1 मिनट में टूट गया. Your life is not that easy, a game that can be played so easily. So you have to plan, and the strategy to plan, the means to achieve that greater goal have to be easily identified, not easily identified, but strongly and with commitment you have to achieve them. So the social nation building is dependent upon that. Yes, among resources and scarcity of resources, the competitive world is there. But then within that, as isolated unit, as isolated community, as isolated groups and families and individuals, we have to have a very concerted, calculated and prudent approach to tackle all these issues. And in conclusion, I would say that ये सब तो लिखा है, you can always read that. But then a cautious approach, a very pragmatic approach, a calculated approach. Calculated if it's not a right word, but then let me use it for a while. Why calculated? Because we are talking about input and output. If we give this much, we need to have at least this much. So input output calculation is very important. How much inward energy, how much attention, how much focus, how much commitment do we invest into this? And what do we get out of this? Is it worth investing this much? We take certain calculated steps. It's like ultimately at the end of the day, balance sheet. We all worry about our karma ka balance sheet, that whether I'll go to heaven or hell, but we are creating a hell by not taking care of the balance sheet of our deeds every day, in order to satisfy the unseen balance sheet over there. So what is very important is that we have to understand, if not global responsibility, this is a big word, make it a national responsibility or community's responsibility. Have a moral responsibility and empathy. Don't need sympathy, empathy to understand, because sympathy may you just look like this and then walk away. Empathy may you say it's your accountability कि मुझे करना है साथ में, है ना? And have appropriate legal frameworks and enforcement agencies to do this. These are humanitarian crises. We have to understand it. They just do not want very bad. They want much more than this just lip service. So that is there. And we have to address the cause. Causes address करो. ये ऊपर banded approach है ना कि ऊपर ढक दिया, नीचे the root cause has not been addressed. This needs to be done. And my dear friends, prevention is better than cure. So address right in the beginning so that it's never too late. These are some of the sayings, but sayings are baatein hain, baaton ka kya, by good people, Albert Einstein, Nelson Mandela, Shakuntala Devi and Mahatma Gandhi. But I would like to say thank you to all of you for your patience and listening to me. Yeah. Over to Aparna. Yes.
Yes, thank you so much, Dr. Sheetal ma'am. It was really fabulous, and hope the participants have enjoyed the connection. So I could not find a question in the in the chat box. So I hand it over to Govinda. Govinda, continue.
Thank you very much, ma'am, for such an energetic session and pointing out that we need to look at our epics with new dimensions and comparing it with today's scenario. I can see no question, as ma'am said. Everyone seems highly satisfied, motivated with this lecture from their comments and reactions.
Okay, thank you so much.
Now we are in the concluding part of this session. I would like to read vote of thanks. On behalf of MLNG Society's Manikchand Pahade Law College, Aurangabad, I express my deepest sense of gratitude to our today's resource person, Dr. Sheetal Sharma ma'am, for enlightening us with her words. I would like to thank Professor Shivkanya Kadam ma'am for introducing sub-theme of this session. I also thank coordinator for making this session successful. I also thank all our attendees. The next session will focus on protection of children from Sexual Offences Act and the Juvenile Justice Act by Honorable Dr. Asha Bajpai ma'am. For that, I hand over charge of further session to Mr. Kaushal Singh. Over to you, Kaushal.
Thank you so much, Govinda. I go ahead and request to ask audible and visible to everyone.
Yes, you are audible, but still not visible.
Thank you so much, ma'am. As they say, all glorious things come to a glorious end. I, Kaushal Singh of BA LLB third year, welcome you all to the last and final session, that is session 4 of online training program on child rights, which is going to focus on the POSCO and the Juvenile Justice Care Act. Before I go ahead and introduce our keynote speaker, I would request Professor Ms. Kritika Temburnekar ma'am, Assistant Professor of Law at Government Law College, Mumbai, to introduce the theme of this session under 2 minutes. Over to you, ma'am.
Okay, am I audible, Kaushal?
Yes, ma'am.
Okay. Thank you, Kaushal, and very good afternoon to one and all present here. I am Ms. Kritika Temburnekar, Assistant Professor, Government Law College, Mumbai. First of all, I would like to thank the organizers for such a wonderful, wonderful online training program. I just want, it should not just, it should not be the final session. It should keep on going on and on and on. But yes, everything has to end. So I would like to thank also to the organizers of this program, especially Dr. C.M. Rao sir, Principal of Manikchand Pahade Law College, Vice Principal Professor Shri Kishan More sir, Professor Dr. Aparna Kodapalle ma'am, and all others for giving me this opportunity to introduce the sub-themes of this session. This final session of today's training program is focused on 3 aspects. One is the protection of children from Sexual Offences Act. Secondly, it would be focused on Juvenile Justice Care and Protection Act 2015. And the third issue will be of the problems of missing children. Now, before I begin, as we all know that this training program, in this training program, the participants from various disciplines, including arts, commerce, and science, have joined. And hence, instead of focusing on only one particular right and discussing it from only technical perspective, the organizers have chosen a broad theme to provide a comprehensive orientation to all the participants regarding the child rights. And I think the idea of organizers is getting successful here. Now, coming to the first sub-theme of this session, that is the POXO Act. The act is enacted basically to protect children from the most heinous crime of all time, that is the sexual abuses. And sexual abuse of a child is not just a crime against that particular child, but it is a bloat on the entire society. It trembles the human consciousness. It takes away our faith in humanity. It affects children not only physically, but it scars them for their life forever. Their minds are scarred. And hence it is very much necessary to talk on this topic openly to make sure that our human consciousness is still vigilant and empathic, and we are working our best to make this world safe for our children by enacting laws like POCSO Act. Now coming to the second sub-theme, which circles around the Juvenile Justice, Care and Protection Act, which deals with the issues of children in conflict with law. Nowadays, we do not call them the child offenders or juveniles, because these are the children who do not have, the idea, the prudency to know the consequences, or they are not mature enough. So we cannot call them criminals. These are the children in conflict with law. And therefore, we have this special act, which is enacted in furtherance of the objectives of United Nations Convention on Rights of Child, which was ratified by India on 11th December 1992. So this act actually addresses on curbing the offenses being committed by as well as against the children by providing a guaranteed procedure for its redressal through Juvenile Justice Board, Child Welfare Committee. The Act also deals with the remedial provisions for the children in need of care and protection through various governmental and non-governmental institutions. It also talks about the issues like adoption of orphan children and the rehabilitation and social integration of children. And now coming to the third sub-theme of the last session, which deals with the missing children. Now, this topic is of my daily observation as I live in Mumbai, and like all others, I travel by local trains. Also, I have my NSS team with whom I organize various programs and activities for children who are living in some slum areas of Mumbai. And there we see that there are a number of children who are begging and selling goods on footpath and in trains and in parks and everywhere. Either they're alone or they are with other kids. I always wonder, whose kids are these? Are they forced to beg by their parents, or are they just got wandered off from their families, got cut off from their families, and are they kidnapped and trafficked here for begging or some other illegal purposes? And unfortunately, today we have become so accustomed to the news like children gone missing or babies gone missing, kidnapped from the hospitals. For a while, for a couple of minutes, we express our sympathy, become sad, and then we carry on. But this issue needs to be given more attention than just being sad and being sympathetic about it. The International Center of Missing and Exploited Children, they have made a survey of like number of nations, and for India, they have estimated that approximately 96,000 children, they go on missing. The missing reports every year are filed for approximately 96,000 children every year. So you see that where exactly do we stand? Now, what happens with them? Whether they ever get found and returned to families or not? What laws do we have? What are the machineries? And what are the mechanisms? Whether these kids are ever brought back to the families or not? And who's responsible if something happens with these kids? There are hundreds of questions which pop in our conscious mind. And hence I believe that in this session, our esteemed speaker will help us to understand all the aspects like offenses against children, need of care and protection, the procedural guarantees to curb such issues to ensure the healthy growth of our future, that is our children. And so with this, I will briefly conclude the introduction of the sub-themes of this session, and I look forward to be enlightened on these aspects by our esteemed speaker, Professor Dr. Asha Bajpai. Thank you everyone for your patient listening. Over to you, Kaushal.
Thank you so much, ma'am, for such great introductory insights. Now, for the most important moment, as our keynote speaker today, we have Dr. Asha Bajpai, ma'am, retired professor of law at the Tata Institute of Social Studies, Mumbai, whom I would like to introduce. Professor Dr. Asha Bajpai, ma'am, entered full-time academics commencing from the National Law School of India, University, Bangalore, where she also obtained her MPhil and PhD in law. She has specialized in child rights law, access to justice for vulnerable and disadvantaged. Ma'am was involved in teaching, research, training, gender justice issues, legal aid, clinical education, and legislative reform relating to vulnerable groups for more than 3 decades. and founding Dean of School of Law at the Tata Institute of Social Sciences. Ma'am designed the unique LLM course on access to justice for preparing community lawyers. Ma'am has been involved in several law reform projects and capacity building of judicial and law enforcement officials. Ma'am was project director of field action projects such as Legal Services Clinic for the marginalized and vulnerable groups and Chunauti for rehabilitation and social reintegration of orphaned children in institutions. Ma'am has been the lead speaker at several national and international conferences and has been invited as an amicus curiae, an expert by the Bombay and Delhi High Courts in matters of public interest litigation. Ma'am was also an invited expert at the UNESCO high-level meeting on ECCE and by the United Nations ODC on education for justice. Ma'am has also served as lead speaker for and faculty at various national and international universities and esteemed conferences. Ma'am has several publications to her credit. Her book on child rights in India, Law, Policy and Practice, published by OUP, is now in its third edition. Her other publications include From Exploitation to Empowerment by Macmillan Publishers, Adoption Law and Justice to the Child Sexual Abuse, Need for Law Reform, to name a few. Ma'am has recently retired from Tata Institute of Social Sciences, Mumbai, and is now a visiting faculty at several national and international law schools. Ma'am has also been involved in consultancy assignments for the United Nations organization and continues her capacity building and law reform projects. Ma'am is currently also working on a book on legal aid for children. Thank you so much, ma'am, for your gracious presence. Over to you, ma'am, for the session.
Thank you, Kushal, for this very kind introduction. And I would like to thank, am I audible, everybody? Yes?
Yes, ma'am.
Hello? Okay. So good afternoon, everybody, and thank you to the organizing team, especially Principal Dr. Rao and Vice Principal Dr. More, and your very efficient coordinator, Dr. Archana, who very persistently and efficiently they coordinated the entire session as well as the invitations. I would like to I'm happy to be with all of you. So many students here, so many faculty here. I have a small presentation, but I would like to make this session interactive. So I would like you to respond. I have some questions with me. So I would like you to respond as and when it comes up. So, and I have two challenges in this session. One is such excellent sessions before me. And second, it is nearing lunchtime. And many of you must be waiting. Your lunch must be waiting for you. So I know it is a challenge for me. But anyway, I'll try my best. Let us see how it goes. Just share my screen. Just let me know if you can see it. Is it visible?
Yes,
Yes, ma'am. Your screen is visible.
Okay, thank you. Okay, so I begin. I know it is nearing almost lunchtime now. So I would like to know how you feel now. How do you feel today in any of these emojis? What is your reaction? Are you happy? Are you sad? Are you feeling very lovely? Are you feeling awesome? Are you feeling sad? Are you feeling like crying after listening to all of us such a long sessions? Anyway, I would like to know, yes, I know some of you are reacting in the chat box. Many of you are happy, good, awesome, good. I know, let us go ahead now. I'm happy to meet these challenges now after knowing your reaction. You all know we are, in India, we are home to 19% of the children of the world. So many children are there, and we are in our country, they make a large proportion of our population. So we have 39%, nearly 40% of the country's total population are children. And 29% of that children are between 0 to 6 years of age. So we need a lot of, we are talking about a large group of our population when we talk about their rights. You have heard about a lot of rights since morning: survival, development, education. Why do you feel children need special rights? I need in one sentence. Why do you think children need special rights? Yes, anybody? You can speak out if you are unmuted. Anybody, very quickly, because I have a they are future of a country. One somebody has written, yes, they need special rights, but why? That's what I want to know. Why do they need special rights? Why? We have you've been hearing about their rights, CRC convention. Why do they need special rights? Anybody?
As they are vulnerable.
As they are vulnerable. Yes, they are more vulnerable than the others. They are more vulnerable than the others. So when we talk about our constitution, we have so many constitutional rights, the fundamental rights, the directive principles. There are more than 250 laws in our country which give protection to children. And besides that, you have the substantive laws like the Indian Penal Code, the Indian Evidence Act, the Criminal Procedure Code. We have also ratified many international conventions, including CRC, Hague Convention, many other conventions we have, that you have heard since morning. That is what, and also we have the rights, they all have the same rights as all citizens of India because they are citizens of India. So right to equality, right to non-discrimination, right to personal liberty, all that, right to be protected from exploitation, all those rights they have. But in spite of that, they have certain special rights which are given in the Constitution of India. And one important right that I would like to share with you, which all of you are aware of, you are all law students, which all of you are aware is Article 15(3) of the Constitution, which says special rights for children, special rights for women and children. So keeping this in mind and keeping all this in mind, we use a rights-based approach. That means we look at laws, we look at rights, we as children's rights with a rights-based approach. Are their rights being protected? Is the right to survival, right to development, right to protection, right to participation, which is also an important right. All rights are equal. Not that right to education is higher than right to recreation. No, right to recreation, right to play is equally important as right to education and right to survival, right to life. All rights are equal. So when next time when you're talking to any child, don't say, go play, education is more important. Don't play now. Play and education and recreation are equally important. Okay. So now, based on these rights, we have some special laws for children. And Child Marriage Act, Prohibition of Child Marriage. You heard about Child Labor Act. You heard about Right to Education Act. I'm going to speak about POCSO and about JJ Act. And you also have IPC provisions. But because of time constraint, I'll be speaking about these two laws and a little about missing children that is there. Now, if you come to the Juvenile Justice Care and Protection of Children Act of 2015, you know the circumstances under which this act came into force. Remember the infamous Nirmaya case, where one of the accused turned out to be a child who is below 18 years of age. Now this, as the law was that time, Juvenile Justice Act of 2000 was prevalent at that time. As per this law, he was a child. He was a child, and so he was treated under the prevalent Juvenile Justice Act of 2000. Now, because of that, because of being leniently treated, there was a big hue and a cry and a lot of processions, marches, talks, discussions that why should he be let off so leniently? According to media reports, he had committed the most heinous crimes. That was there, that I'm just talking about reports. And that is why you had a new act called the Juvenile Justice Act of 2015. And this act, started talking about, brought into focus all the rights of the child, CRC, also brought into focus the Beijing rules, the Riyadh guidelines, all these are international laws, plus our constitutional provisions. All were taken into this. And it was supposed to be a law with a rights-based approach, with taking into consideration the rights of the child, which we have ratified. Now, and also our constitution provides for us. So this Juvenile Justice Act used very child-friendly terms. So from juvenile is supposed to have stigma. Oh, you are a juvenile, sometimes you tell people. But so they said, no juvenile. You convert the word juvenile into child. So you have child instead of juvenile under the new act, though the title of the law remains the same. It should have been Child Justice Care and Protection of Children Act, but it is still Juvenile Justice Care and Protection. Maybe in a hurry they forgot about it. So child and a child in conflict with law. You don't say juvenile in conflict. So all you sensitive students, I know all of you are, will nowadays now say child in conflict with law and child in need of care and protection. So there are two categories of children who are below 18 under this act, are covered in this act. One is child in need of care and protection, means they have done no wrong because of the circumstances in which they are, like orphans they are, or they are, victims of natural disasters, or they have parents who are not fit to look after themselves, they are sick, they are terminally sick, or because of poverty they cannot look after. They are all children in need of care and protection. A new category was added in the 2015 Act, and that was a child who is in danger of getting married. So a child below 18 who is in danger also is a child in need of care and protection. Children who are going to be sexually abused or physically abused or exploited in any form are also children in need of care and protection. And it's a very wide, as the Supreme Court has said in a decision in 2017, which is very famously known as the orphanages case, the exploitation of children in orphanages case. The categories are illustrated. There are huge lists in that act in the definition section, but they said these are only illustrative. They are not exhaustive. So you can go and increasing this as per the circumstances of each child. Now, child in conflict with law means a child who has committed an offense as per the laws of our country. But there's a thin line between a child in need of care and protection and a child in conflict with law, which all of you will agree. So, but because of the hue and a cry at that time, the 16 to 18 years, there were two categories of children under the child in conflict with law. One was below 16 and one was between 16 to 18. The Nirbhaya case impact and the impact of all the noise and the protest that was going on. They said children between 16 to 18 years should be treated in a different manner if they have committed a heinous offense. They categorized the offense into three categories: heinous offenses, in which the punishment as per the various laws, say IPC and other laws, is more than 7 years, and serious offenses, the punishment is between 3 to 7 years, and below 3 years is petty offenses. So in case of serious heinous offenses, if a child, then he should be treated in a different manner, he or she. And the Juvenile Justice Board and the Child Welfare Committee are the two structures under this act. The Juvenile Justice Board looks after child in conflict with law, and the Child Welfare Committee looks after children in need of care and protection. And they are, they are constituted by people who are aware of the children's rights and they are sensitive about children's rights. So as far as children between 16 to 18 years are concerned, if they have committed a serious offense, then in that case, they will have to, the case will be first assessed by the Juvenile Justice Board, which is known as preliminary assessment. And after that, if they feel that this child was aware of the consequences of his action, aware of what he was doing was wrong, then in that case, his case will be transferred to the children's court, which is a court of session transferred into a children's court. And this children's court will send the child to a place of safety till they attain the age of 21 years. And again, assessment will be done, evaluation will be done. And if the child has improved, because in the place of safety, a lot of interventions will go, say education, life skills, vocational training, whatever is suited to that child will be done. And after that, evaluation will be done. If they have improved, they will be sent out and into the community and to lead a normal life. But if they have not improved, then they will go back to the adult court, adult criminal justice system. So this is the very brief scheme that is there under the Juvenile Justice Act. I'm just sharing with you a case study. I would like you to respond to it quickly. This child was 17 at the time of crime. So he was tried for rape, murder, and sentenced to 3 years in a reform facility. That time it was the Juvenile Justice Act of 2000 that was prevalent. So the maximum sentence available that time to a child in conflict with law was 3 years. 3 years
in a special home because he's a child in conflict with law. So now let us look at the background of this child. I want you to listen to the background, listen to his offenses, and also let me know that as per this current law, is he a child in need of care and protection, or is he a child in conflict with law? So just listen to this case study in that manner. He was the eldest of 6 children who left his village somewhere in northern state of Uttar Pradesh at the age of 11. And he lived his 11 to 16 or 17 years, that means the formative years, alone in Delhi, in a place like a city, big city, doing menial jobs, like wherever he would get a job, in a garage, in a dhaba, wherever he would get a job, he would do some menial jobs, and he made his life. His family is the poorest of the poor in the village. It's a small village from where he comes from. Father is mentally disabled or intellectually challenged, to use a sensitive, and he cannot take care of the children. That means, as per the JJ Act, his parents are unfit. His mother says that she sent him to work in the hope that he would earn a living. And remember, there are 6 children in the family, and he would earn well in a big city, and he would bring the family out of poverty. He sent the family money, small amounts which he used to earn initially, but later, then he stopped and he disappeared. Nobody knows where he was. In family also did not know where he was. His mother said he was a gentle boy, sensitive. He was scared to confront anybody in the village. And she felt that he fell into bad company. And so that's why he did this murder and rape and all. Because as per the law, he was sent to a special home, correctional home as they call it. And then afterwards, he stayed there for 3 years. And later, as per the law, he was released. I would like to know whether this child is a child in need of care and protection according to you, or a child is conflict with law. He has committed heinous crime of rape and murder, which has sentences more than 7 years. Now, I would like you to apply the 2015 Act. Is he a child in need of care and protection, or is he a child in conflict with law? Very quickly. Should he be tried as an adult for a heinous crime of rape and murder? Very quickly. As per the new Act, heinous crime is more than 7 years punishment, and this act of rape and murder is more than 7 years. Anybody? Because the chat box is not visible to me. So if you are writing in the chat box, somebody will have to read out to me, because I'm not being able to see the chat box. Any answers? Anyone? Or should I go ahead? I'm not hearing from anybody. Yes, Govinda, I'm seeing your hand. You would like to say anything?
No, ma'am. No, ma'am. There was
Okay.
just irrelevant comment in comment box.
Okay, so I'll just go ahead. See,
Yes.
look at his background. See, there's a thin line between, Ganesh has said he's a child in need of care and protection, though he has committed a heinous crime. Ganesh, what you have said, because is also right, because every child in need of care and protection, if not taken care of, becomes a child in conflict with law. See, if this child, when he was 11 years old, at that time, somebody had taken care of him. Somebody had looked after his right to education, his right to survival, his right to development, his right to health. Then in that case, this child would be, this child who was a child in need of care would not have become a child in conflict with law. So there's a thin line between C and CP, as we call it, child in need of care and protection, CICL, that is child in conflict with law. Remember that when you are dealing with children and their rights. I would like to also say that though he was tried for heinous, that time the 15 Act was not there, but He is now out of that special home and he is doing some kind of a employment there, and his identity has been hidden. It's not revealed. As per JJ Act, your past has to be completely wiped off and you have to have a fresh start. There is a principle of fresh start and you have to, nobody will look after at his background. So remember that. Now there are child-friendly rules in the JJ Act. There has to be a child-friendly environment and Juvenile Justice Board and Children's Court. Now, when you're going to I hope you have opportunity later to go and visit a children's home and a Juvenile Justice Board and a Child Welfare Committee in operation. Now, when you go there, you must first observe whether is it child-friendly environment? I have been to several Juvenile Justice Boards and Child Welfare Committee. And I will share with you one example. I was there in this Juvenile Justice Board where this where a case was going on of abuse, in which the offenders were children who were below about 15 years, 16 years old. And the victim was a girl of about 8 or 9 years old. Now, in this Juvenile Justice Board, the victim and the children and the offenders were standing in front of each other. And the magistrate, who is the principal the member of the Juvenile Justice Board, asked the girl, "What did these boys do to you behind the bushes?" Now, when she couldn't answer, obviously, all of you will understand. How will a 8-year-old girl answer this question in front of those two boys? It is very difficult. It's not easy. Even we will not be able to answer. Even we will not be able. So it's difficult. So you'll need to have a child-friendly kind of an environment where you see to it that you are shielding, protecting the child who's going to say something to you. So this kind of environment, you just check, and you should not have bland walls all around, the magistrate sitting on a high pedestal, and there's a table. Remember, children get scared of table and chair and high pedestals. And also you should, one more thing I noticed in that Juvenile Justice Board, the children are not aware why they are before the Juvenile Justice Board. They are literally trembling. Especially the girl child there was trembling. And so she held the table for support. So which was very rudely by the typist told, "Don't stand straight." All are standing. Why not sitting down? Why not allow them to hold the table? So these are all child-friendly environment in Juvenile Justice Board. I hope as students, when you're going to visit all these, you observe all that and you write about it and you talk about it and your advocacy you do about it, that this should be a child-friendly. The hall should be friendly to children. The room should be friendly to children. Okay? No handcuffs, no kind of fetters. I've noticed they put handcuffs and remove it just before they enter the court premises. Okay? So they say if they run away. But then you are there to a few hefty people. You can manage. No corporal punishment. No corporal punishment is there under the JJ Act. So in institutions, there should be no corporal punishment. There is punishment for the people who do corporal punishment. It's there. You must have heard of that. No capital punishment or life imprisonment is given under our JJ Act. In some countries they do give, but not in our JJ Act. There is another important feature of the JJ Act. I don't have much time, so I'm just doing an important feature. The individual care plan, ICP as it is called. So when this is one area in which students can be a great help. See, our parents make care plans for us that when you are 16, you will join this college. When you are 18, you'll do this, you'll do science, you'll do commerce, you'll do computers. You need to prepare an individual care plan for all children and institutions, taking into consideration their background, their health, their education, and their all these aspects have to be taken, and an individual care plan. So ICP has been made a mandatory part of final orders when they are looking at, when they are sentencing children in the Juvenile Justice Board and Children's Court. So, and this ICP is legally binding. And they have to follow it, whether it's an institution or in the family or in the wherever the child is placed after that. The ICP, the individual care plan, is to be followed. In this, the education of the child was going to school, that school has to be continued. Schooling has to be continued. So all this has to be taken. If the child was suffering from some disease, the treatment, the medical treatment must continue. This is the individual care plan. Child-friendly provisions are there in the new JJ Act. social investigation reports. The background of the child should be found out before orders are passed. What is the background? What is the family background? What is the poverty structure in the family? Juvenile Justice Board, Child Welfare Committee, Children's Court all have to give individual care plans. Child-friendly atmosphere is mandatory in JJB and Children's Court. So you need to this. And one last point in the JJ Act that I would like to stress on, I've not done the whole act, some important provisions, is that no stigma. As I told you, principle of fresh start. If a child is found guilty of a petty or serious or crime, this will not disqualify him from admission into any educational institution. Okay, child found guilty is not given this kind of protection of heinous crime, but child found guilty of petty and serious crime, no this. The other act that I have to speak to you about is the POCSO Act. I have a quiz, true or false. I think you can quickly tell me about this. And they are very simple. You have heard about them since morning. So it will be very simple. Only girls are vulnerable to child sexual abuse. Is that right? No, correct. Correct, Satyam. Absolutely right. Yes, Praveen, you are also right. Harin, false. Harin, why are you saying false? Can you let me know? See, why I'm saying that even boys are vulnerable, because boys are also vulnerable to sexual abuse. I will give you some statistics which will show, yes, both male and female, yes, is abuse. Boys are also facing. Now, both boys and girls, right? Question 2. An abuser can be someone who knows or is related to the children they abuse. Is it yes? Yes. Right. Right. Rajpreet, yes, right. Mrs. Srikanth, yes. Jagannath, yes. Yes. Because what is happening, we are seeing people, almost 99% of the cases, the abuser is known to the child. It's somebody from the family, somebody close to the family, grandparents, uncles, cousins, pizza boy, lift man, gardener, caretakers in the institution. All these are involved. Somebody whom the child knows and trusts also. Child sexual occurs only in certain types of families, maybe broken families, maybe families who are poor. Is that true? No. Yes. All of you are unanimously saying no. Yes. Yes, it is correct. Absolutely correct. All of you. It happens to everybody. It can happen to anybody belonging to any family background, whether you are rich or poor, staying in an elite society or going to an elite school, or staying in a slums, or staying in urban area, or staying in rural areas. It can happen anywhere, and it can happen to anyone, any place it can happen. On the street, at home, outside, in school, anywhere it can happen. Sexually abused children may not disclose their abuse to others for many reasons and may also deny its occurrence. True. Yes, Satyam. True. Yes, Bhageshri. Yes, Ganesh. Yes. So all of you, because you know what happens is that they do not disclose to others because they are scared. First of all, they are scared. And secondly, these people are known to them. They are very close to them. How can they talk against them? How can they talk against them? So it is very difficult for them to say. For instance, take us also. If I know someone very close to me and that person has done something wrong, I'll be hesitant to talk about that person. Blame that person. It is very difficult, very difficult. Children with disability can also be sexually abused. Exactly. Yes. Yes, they are. Yes, Pooja. Yes, they can. In fact, they are more vulnerable. That's the reason why I asked you, what's the special reason? Children with disability are more vulnerable. They are victims because they have disability. Many of them are intellectually disabled. I was an amicus in one case of intellectually disabled children who were sexually abused, and they came before the criminal justice system and gave evidence through sign language. And they gave evidence. So the first time a group of children came before the criminal justice system and gave evidence in a sign language. Okay, so this is there. So, and they were protected. as per the new POCSO Act. I'll come to that. So sexual abuse in children, around 53, study was done by the Department of Women and Child Development in 2007. And 53% of Indian children reported experiencing different kinds of abuse. And in as many as 109 children were sexually abused every day in India in 2018. It's a very sad and a grim case, very sad, a very sad situation, shocking case situation. Yes, yes, Dr. Himanshu, shocking situation that are there. And during pandemic, during COVID, this increased. The helplines were flooded because what had happened, the abusers who are generally known to the children and the victims were locked together. They could not go out many times. So and so the cases increased during pandemic. It's a serious crime. A 2020 report by NCRB shows that 100 children are sexually abused every day in India. Maharashtra, since we are talking here in Aurangabad, Maharashtra recorded the highest number of child rapes, that is 2,832, followed by Uttar Pradesh at 2023 and Tamil Nadu at 1,457. This is NCRB data of 2020. And 2021 trafficking in person report 95% rise in online search for child sexual exploitation material. Why? In 2021, pandemic, everybody is online. Everybody is at home. So the search for child sexual exploitation material increased by 95% during pandemic. And India saw an 82% rise in child rape cases from 2015 to 2016 in the wake of COVID. During the very first 11 days, 30% of the calls were regarding to abuse of children in Childline, which is a child helpline, 1098. So Childline saw an increase of 50% calls in this period, and out of this 50%, 30% were all child sexual abuse cases. Now let us look at the law. Now the POCSO, as Protection of Children from Sexual Offences Act, known as POCSO, in this, it is about protection of children from sexual assault, sexual harassment, and pornography. There are different definitions for all this, which as law students, all of you can go through it. And even students who are not law students, they will know that there are various kinds of abuses, which you briefly mentioned. There could be penetrative abuses, where you penetrate the private parts of children, and non-penetrative abuses where through touch and through show, maybe you show pornographic materials, or where you distribute pornographic materials, or your sexual harassment is where there's non-touch abuse, there is touch abuse, all kinds of abuses are there, and there are different punishment for them. In the POCSO Act, before POCSO Act, we had no law for protection of children from child sexual abuse. We were using IPC provisions, which were not suitable for children. Now we have a special law for children, thanks to Section 15(3), and thanks to CRC and other child rights law that you have already done. And this is gender neutral. Why? Because as all of you rightly said, even boys are sexually abused, not only girls. So this is a gender neutral law, and the age has been increased to 18 years. As per CRC Article 1, a child is defined as a person below 18 years of age. So this law has taken a child rights based approach, and 18 years is the age of child. And as I told you, there are various calibration of offenses. Penetrative offense, where you penetrate the private parts. Non-penetrative, where it's not through penetration, it's through other ways. Non-touch, where you don't touch, but you show your parts. Maybe your private parts are being shown to a child. Use of pornographic material, that is you all know obscene material that is done. So all these are various kinds. There are various punishments for it, and all these offenses have become aggravated when committed by a person in position of trust and authority. For example, if a closely related person is doing all this, then it becomes an aggravated and the punishment is more serious. Okay. So, and there is a 2019 amendment recently that was amended, that in which punishment for certain offenses related to child pornography is increased. And also they have included digital and even computer generated images, photographs and videos in that. Aggravated penetrative sexual assault, they have added 2 more punishment. One is causing death to a child, during the abuse, and also assault during natural calamity. That means during COVID, during flood, during riots, then it becomes aggravated, and aggravated is 10 years has been increased to 20 years, and maximum punishment is death. 2000 amendment, so I have done that. Now these are some of the key features which I have quickly put into this. Child is 18 years. There are a lot of sexual offenses. Mandatory reporting. Mandatory reporting is a very important feature of this act, which says that if you come to know that a child is being abused or is likely to be abused, then it is your duty to inform the police about it. Okay, you cannot keep quiet, because if you keep quiet, the reason behind this mandatory reporting is that if you keep quiet, that person will be encouraged, will go on and on. There is no end to it. So mandatory reporting is there in that. So, and then you have medical care, then you have child-friendly procedures in this, and special courts for such cases, and compensation also. In the case that I was doing as an amicus, each child was given, both boys and girls, 3 lakhs of rupees as compensation. So mandatory reporting, that means you have to report to the police about this offense, and the police is duty bound to file an FIR. The burden of proof in the cases of aggravated offenses is shifted on the accused, and intent to commit an offense is also penalized even if it is unsuccessful. And attempt also is penalized, though the punishment is half. And abatement is, for abatement, the punishment is same as for actual offense, and no discretion is given to the court to reduce the punishment. Now, what are the child-friendly procedures? At child's residence, you have to take his statement, or if the the abuser is in the home itself, then take the child to a child-friendly place, say a school or a friend's place or a teacher's place, and take the advice of the child. Simple language you have to use. So, and the same language the child speaks, you have to write in the FIR. You can't say section 375 and section 4 of POCSO. No, the child must have said in his or her simple language. The child won't use sections. The child will say, this is what he did, bad things to me. He did that to me. He removed my clothes. All that will have to be written in the language of the child. And assistance of a translator if required, or a sign language expert is required. Presence of a parent or a guardian, and also as far as possible, audio video recording, so that you don't have to keep on repeating. Now, the 164th statement, CRPC statement, where you give the statement in front of a magistrate, and that also has to be recorded. And that time the accused advocate is not required. And the child-friendly court, where it has to be a child-friendly environment, and the child should be given breaks. The child should have a support person, and child should not be called repeatedly to testify. And girl victim, you need to have a lady doctor as far as possible. The examination should be conducted by her. Now, all of you must be wondering how, maybe you're all students, you're all teachers, you may come across cases. How will you identify such cases? It's not an exhaustive, but somehow, unexplained injuries on the body, especially private parts. When we had gone to look at some children who were abused, we found unexplained injuries on the hand, on the face, on some parts of the body. Difficulty in standing or sitting. See, if you visit a home, many times you see children are unable to walk properly. So that is another sign. Constant, they sleep in the class. That's another class. Engaging, they have, drugs. One of the famous drugs that children normally in institutions have is cough syrup. Then increased awareness of their sexuality and appearance, and sudden withdrawal from people or places. They used to be very friendly earlier. Suddenly they have become withdrawal. And they have feelings of guilt. They have feelings of confusion, powerless. They blame themselves. Oh, something is wrong with me. That is why this happened to me. They feel stigmatized and they feel helpless about the whole situation. They don't know what to do. They start scoring low marks, poor attendance suddenly. And they start withdrawing, avoid drawing attention to them. They don't want to, be in the background. And they start, some people suddenly start overachieving. That also is a sign. So what will you do when you come across a case of child sexual abuse? How will you react? Will you say, something you must have done? Why you only got abused? Why others did not get abused? Something you did? The way you dressed? Generally, this is what happens whenever there is a case. You say the dress of the girl was the problem. No, you should not blame. You should not get panic. You should not scare the child and ask why this happened to you. Blame the child. You should not say, don't tell anyone, keep quiet. I don't believe you. Some parents also say that. I don't believe you. This can't happen. How can this friendly grandfather do this? How can your own father do this? How can this neighborhood uncle do this? This is your fault. You should never do. These are the don'ts. You have to listen to the child carefully. Assure the child that this is not your fault, and assure that they have not done the right thing, and listen to them, believe them. Tell the child that he or she is brave. Tell the child it is not his fault. There is this e-box in the NCPCR website where you can give awareness. As students, you can spread attendance. When you can spread awareness of this box. Any child can press this button in the NCPCR website, and they can say that what has happened to them. There's a form there which they can fill. And if they can't write in this, there are images which they can tick and say this is what has happened to them. Then there is 1098 helpline. So these are some of the things that you can do when you come across a case. I'm going fast because there are some questions I can see. Missing children is another issue that I have to deal with. One child goes missing every 8 minutes in the country. Sad. Most of the missing children end up in a situation of exploitation. I think it was Kritika who mentioned that she sees children in the train. Many of the children in the train were maybe picked up when they were small and made forced to beg, forced to be beggars. Many of them were maybe trafficked. Many of them they become drug peddlers. Many of them are sold for organ trade, illegal adoptions, child brides in other countries, Middle East, especially Middle East, and they're married to men for 5 times their age. They're also forced to become child soldiers in some countries. In 2019, about 73,138 children were missing. Okay, 71% of them were girls. In Maharashtra, the number of missing children cases increased by 166% in 2019. That was there. So missing children has been defined under JJ Act. If you see Rule 92A of the JJ Act, the missing children have been defined. They are the children who are below 18 years. Their whereabouts are not known. They're to their parents, legal guardians, and other person who may be legally interested. And they are the cause. Human trafficking, yes, Dr. Himanshu, human trafficking. So the Juvenile Justice Act includes missing children as a child in need of care and protection. Okay, and Rule 92 gives the definition of missing children. Now, in Bachpan Bachao Andolan, which was a PIL in the Bombay High Court, in the Supreme Court, there are given certain directions which all of you should be aware of regarding missing children. One is that as soon as a child is missing, see, when many movies and TV serials show you wait for 24 hours and come. No, if the missing person is a child below 18 years of age, then in that case, it is a presumption that it is either abducted or trafficked. And so FIR has to be immediately filed. It is mandatory for the police to file a FIR in case of a missing child. There is a special procedure, operation procedure for missing children that has been, because of the Supreme Court judgment, that has been formed. You can have a look at that online. In that procedure of operational procedures, which are given to all police, all stakeholders, all parents, all NGOs, all of you must be aware of it. Any parent, legal guardian, relative, child welfare committee, child line, NGOs, police, public servant, any person concerned, any person who has knowledge, even you, all of you, can file a complaint of a missing child. Where to file a complaint? Police station. Or there is a special juvenile police unit under the JJ Act, who has been appointed. There is a special designated police in every police station for children's issues. And there is a anti-trafficking unit, which is also there. You can dial 100. You can, some states have emergency headline number for children like 104, etc., 103, Childline 1098. After reporting, there is a portal called Track the Missing Child. You can track the missing child there. So the role of the police will be FIR, inform the child welfare officer, go to the special juvenile police unit with a recent photograph, fill the portal of missing children, Hoya Paya also it is known as, copy to the nearest legal services authority and give publicity to it. Risk assessment has to be done, how much an organized crime perspective has to be taken. It is an organized crime. They have to take that. Whether it is just missing, the child has just gone because the child is angry, but it has to be treated as an organized crime of trafficking or missing children. Then when a child is found, also there is a procedure. Produce the child before the Child Welfare Committee, Juvenile Justice Board. Medical examination is done. If the child has a home, verification is done. Where is the recovery? Report to the District Legal Services Authority. And if any offenses are done against the child, that inquiry will have to be done by the relevant person, either POCSO, either if it is sexually abused, or it goes to the JJB. And then there is a monitoring of this operational procedure, SOP, and the supervisory officer monitor the investigation, and if they have to have cooperation. Paralegal volunteers are very important. Now, this is a role which law schools can play. Please train paralegal volunteers on this SOP, on POCSO, on missing children, on rights of the child. So you're doing a very good work. Today you have this training program, but do a training program for paralegal volunteers. Do a training program for legal aid lawyers. Many of the legal aid lawyers are not aware of child rights. So that is an issue that law colleges have to do. And also law students, you have a role in this. You have a role to play. You have to file a missing complaint in this. Even under POCSO, support persons are required. Under the JJB, many of you may be non-law students. If you are students of social work, you can be members of JJB, child welfare committees, and in law students also can be members of JJB. Because JJB is a multidisciplinary committee with social workers as well as a magistrate. And a child welfare committee has social workers and children and experts who are dealing with children's issues. Then the child welfare committee's role comes into play. They assess the needs of the child, because now the child is the child in need of care and protection. If they want medical care, they want to be repatriated back to their homes, or they want to be rehabilitated, they have to be sent to school, they have to be given some compensation, all that the CWC will do. JJB also, in case it's a child in need of care and protection, refer to Child Welfare Committee, pass an ICP, individual care plan of the child. So this is what the JJB has to do. Then you have now you have a separate category in the National Crime Records Bureau. So from 2016 onwards, after this Bachpan Bachao judgment, where the SOP came in, you have a separate category in the NCRB reports where for missing children, missing and traced children. So please, you can have a look at that also. This is the Hoya Paya portal, which you can have a look at. Everything is given in that, the number of children, the traced, the found, and you can track a missing child also. There is a new application called Reunite. Why I'm bringing it, though it is done by an NGO, called Bachpan Bachao. It uses technology of facial recognition software, which will help to report, search, and identify abandoned children on the streets. We still need to see how it is working. We are not yet aware of it, but this is a new thing. I would like to end this by telling you that the Supreme Court has clearly said that it is absolutely necessary for all stakeholders having interest in the welfare of children to work together. This teamwork would include not only government machinery and not only Department of Women and Child, Department of Labor, Department of Human Resources, Department of HRD, Department of Rural Development. All their departments have to work together. It's not only the matter of one department. Also the police, the civil society, the judiciary, the law colleges, the law students. You can create awareness. You can create write articles on it so that things are done well. So all this can be done, and we need to work together. So thank you. I wanted to be on time. So if you have any questions, please let me know so that I can look at the question. Try to answer some of them.
Thank you, ma'am. Thank you so much. Kaushal, please look into the chat box. There are a few questions to be pondered upon.
Yes, ma'am. I'll just take them up. Even before I take up the questions, I would like to thank ma'am for such an insightful and such an interactive session, ma'am. I'm sure we all got to learn a lot, and personally, I got to learn a lot from this. So thank you so much, ma'am. Ma'am, one of the questions which we have here is if a police complaint is registered, and even though a police of a particular state not discharging their duties rightfully are not filing the complaint vis-a-vis the missing child, can the High Court be approached for a writ petition under Article 226? Someone has asked this question.
Okay, okay. See, this SOP of a missing child is a very, very important, what is that called, document, which has to be followed. It was at the direction of the Supreme Court that this SOP was made, and everybody has to follow it. So if it is not followed, it is a contempt, it is a violation, and we need to see to it that, yes, a fundamental right of a child to survive, a fundamental right of a child to life is being violated. Yes, you file a petition if you feel that, and you know when you're law student, as law students, you know when petitions can be filed, under what circumstances can writ petitions be filed, what kind of writ petitions, and if it is a PIL, then what under 226, then what can you, under what circumstances, if there's a group. So for a not as individual case, it's a group case, then only you can file a public interest litigation.
Thank you so much, ma'am, for that vivid answer. Another question, ma'am, which we have is regarding ma'am, if a male child of 15 years old is sexually abused, would keeping the offender and also the child in a rehabilitation center, both the child and the offender in a rehabilitation center, does it not amount to injustice with the child? And shouldn't some punishment be meted out to the juvenile and be treated as a major?
From what I gather from your question is that a 15-year-old child has committed an offense.
Yes, and has, yes, ma'am. This written statement is 15-year-old child, a 15-year-old juvenile has committed sexual offense against a small boy, and both the boy who is the victim and the alleged accused are being kept in a rehabilitation center. So the question, the person who has asked a question is saying, isn't it against the principles of natural justice, where equal treatment is being meted out both to the victim as well as to the perpetrator?
No, I don't think so. This is going to happen. As per the law, if the child is a victim, okay, so the child is a person who is in need of care and protection. The child will be looked after by the Child Welfare Committee and produced before the Child Welfare Committee by the police or whoever it is. And the child welfare, within 24 hours, the police has to produce the child, or inform the Child Welfare Committee, and also produce the child before the Child Welfare Committee. The Child Welfare Committee will look into assess the background of the child, look at the background of the child, look at if the child's background is fine and the child can be sent back home, the child will be sent back home. Or if the child has to be given some rehabilitation, say sent back to school, they may need a hostel, or they may need a boarding, or they may need an institution for the child if the child has nobody. Then the best interest of the Child Welfare Committee will look at. The best interest of the child will be assessed, and based on the best interest of the child, who's a victim, that child will be sent to the that action will be taken on that child. That is a Child Welfare Committee. This is a child in need of care and protection. The child victim is a child in need of care and protection. Now coming to the child offender. The child offender, use the word child, not juvenile. The child offender is a child in conflict with law. Now, child in conflict with law will be produced before the Juvenile Justice Board. And the Juvenile Justice Board will do a preliminary assessment of the child, of the 14-year-old child or the 15, as you have rightly mentioned. Now, this child will, the Juvenile Justice Board will see whether this child, do a preliminary assessment, and will see whether this child was aware of the consequences of his action, or whether he was not aware. He was an innocent child who did not understand what he was doing was wrong. Maybe he was intellectually disabled. Maybe his understanding power was less. Or maybe he understood that what he was doing, he wanted to harm that person. He wanted to take revenge. Maybe he knew the consequences of his action. That he knew that if I do this, this is happening to that child. Then in that case, he has, if he has understood and he's between 16 and 18. Now, this is a 15-year-old child. He's not between 16 and 18. 16 and 18, heinous crime, it will be treated preliminary assessment. Now, 15-year-old is not coming under 16 to 18 category. So he will be treated as a child in conflict with law, produced before the Juvenile Justice Board, not the Child Welfare Committee where the victim is going. He will come before the Juvenile Justice Board. Before the Juvenile Justice Board, the Juvenile Justice Board also will look into his background, his social investigation report, SIR, that is called, will be looked at, and his child welfare officer will look into it, will find out the social investigation report. The Juvenile Justice Board members with one principal magistrate and 2 social workers, it's a socio-legal decision. They will look into it, and in the best interest of the child, they will pass an order. Now, the order that will be passed by the Juvenile Justice Board is that institutionalization is the last resort. The first resort is maybe if it is the less serious crime, it will be warning. But in this case, you said it is a serious crime. So in that case, maybe counseling may help. If counseling they feel is not going to help, then they will go in for giving him some warning. And if not that, then they will say they will say go to a special home. In a special home, there are no children in need of care and protection. There are no victims. So he is not face to face with a victim. So he'll go to a special home where in the best interest an ICP will be drawn when the order is passed, and some orders of community service, some judges pass. Remember, you must have seen one film in which I think it was Abhishek Bachchan who was sent to who broke a traffic signal, and he was sent to a home for the aged senior citizens to look after them. So these are community service orders. So they also can be passed. But in this case, 15 years old, no. He'll go to the children in institutions, if nothing else is, which is the last option, or institution. And there he will be given vocational training or education or counseling or life skills, whatever he needs, or medical attention, whatever he needs. So this is a difference. He won't be treated equally. Yes.
Thank you so much, ma'am, for those insightful and in-depth answers. Now, even before we take this session ahead, I would request the participants who have been selected to give their important feedbacks. Firstly, for the feedback, I would like to call upon Mr. Jagannath to give his feedback. Over to you, sir.
Is
Kaushal, please wait.
Yeah.
Kaushal, please wait.
Is the session over?
Yes. First of all, we will complete this particular session and then we will proceed ahead with the valedictory, ma'am. Sorry
Right.
for the inconvenience.
Right, ma'am. Apologies, ma'am.
We must thank Ma'am
Right,
Rashmi for her
I'll go in.
excellent speech. And please, Kaushal, please continue with the
Yes, ma'am.
vote of
Yes, ma'am. Before we proceed into the valedictory part, my profuse apologies for the goof up. Before we proceed, I would like to give a vote of thanks. Firstly, I would like to thank Dr. Asha Bajpai ma'am for her teachings, and also Professor Kritika Temburnekar ma'am for her introduction of the sub-themes. Lastly, I would like to thank all the attendees for their patient listening and such stupendous questions which have been asked. Once again, thank you so much, ma'am, for gracing us with your presence.
Thank you. Thank you for inviting me. And thank you for listening to me. And thank you for your questions.
Thank you, ma'am. Thank you so much.
Thank you.
Thank you, ma'am.
Yes, Kaushal, we would be starting soon with the valedictory. Let me get back to you. Okay.
Sure, ma'am.
Please.
Sure, ma'am. Also, I would request all the attendees to please not leave the meeting, to stay in the same meeting, and please wait for the valedictory ceremony to begin. We'll be beginning very shortly.
Kaushal, please proceed ahead. I have taken permission from principal, sir. We can start with. Sheetal ma'am, are you there with us?
Yes, I'm there. I'm there. I'm very much there.
Yes. So can we start with the event now? Shall we proceed ahead with the valedictory? Yes. So,
Right,
Kaushal,
ma'am.
please proceed.
Yes, ma'am. As we proceed to the valedictory ceremony, I once again welcome you all to the online training program on child rights. Firstly, even before we start and go ahead and request our senior faculty members and attendees to give their speeches, we would like to have 3 participants to please give their insightful feedbacks, and the feedbacks which have also been given through the feedback link are duly anticipated for all of us to improve for the next time when we have this session. So first up for feedback, I would like to invite Mr. Jagannath to go ahead and give his feedback.
Mr. Jagannath. Mr. Jagannath, are you there?
We may proceed with the next name then.
He's ready. He's ready, madam.
Yes.
Jagannath, go ahead. Introduce yourself and go ahead.
Yes, sir. Please begin.
Professor Jagannath, you are not audible. We are not able to hear you, Professor Jagannath.
Jagannath, you are not able to hear you. Please, you go for another, madam.
Okay. Kaushal, please proceed with the next name. Sir may be ready within few minutes.
Yes. For the second speaker to give their feedback, I would request Miss Yogita Kanoje ma'am to please take over and give her insightful feedback. Over to you, ma'am.
It seems Yogita ma'am has joined on audio mode. It might be difficult for her to join. I could see her on audio mode only.
Whether she is ready or not ready.
She had dropped her name in the chat box for giving the feedback, sir.
No, you go for another person.
Okay.
Sure, sir. We'll take the last person. For the last and final feedback, we have Mr. Ganesh Bhapkar, sir, who will give us their insightful feedback. Over to you, sir. Ganesh, sir, please take over.
Ganesh Bapkar sir, are you there? Unless you make the panelists, they can't make, madam. That is the problem.
We have already made them panelist. Mr. Ganesh Bhapkar.
Now is coming.
Oops. Bhapkar, sir, you're not audible. We do see your mic on, but sir, you're not audible.
Yogita madam, are you ready? Yogita or Jagannath?
It seems there is some problem in the connectivity. We have got to know from the chat box that you people have liked it the most. But still, we wanted to make it more clear in the session. Hence, we were requesting you to give your feedback. Yes, Mr. Kedar Deshpande has also dropped his sense in the chat box. Anybody from the participants would like to come as a panelist of feedback, please let us know. Right now, also, you panel. In this situation, shall we proceed ahead, sir?
Go ahead.
Right, sir. Right,
Okay.
sir. I'll take over, sir. I'm sure that all of the people who were to give their feedbacks would be having great insights and surely a very highly optimistic view of this online training session which we had on child rights. As we go ahead in the valedictory session, I would like to begin and request Dr. Sheetal Sharma ma'am to please take over and give her expressions about this particular training program. Over to you, ma'am.
Thank you, Kaushal sir. And I once again welcome all of you to this valedictory program. And I'm so happy that with the effort of the entire team, everything went so well and there were very good feedbacks. Although, of course, the three feedbackers who had to come are suddenly not available online. But then because of some technical problem, you are unable to interact with us. But I can reflect the general sense of satisfaction that is coming out in the chat box, that everybody is happy with it. Number two, there was a general question when I started talking about that, ma'am, can you repeat what was said in the morning about the program? Yes, being one of the part of the entire team which is organizing this event, these are Jean Monnet activities. And if you type Jean Monnet Erasmus Plus Activities 2021 in the Google, you will get a link. You have to follow that link. Maybe later on with you can contact Aparna ma'am, CM Rao sir and Vice Principal sir. I will share with them the places where you can apply for foreign funding for projects in your area of interest, and you can also take advantage of, and go ahead with your professional career. I would like to personally thank all the speakers for being there, sparing out time from their busy schedule and enlightening all the participants, which have always been above 150, 160, hitting 220 at one point of time, interacting with the participants, making these sessions so lively, so interactive, so enriching, and full of information that at the end of the day, I myself get so enriched and stand humble in front of the august audience. And I wish all of you a good luck and Wish you to have a very fruitful career and future engagements. Thank you so much for inviting me and having me here for this small feedback.
Thank you so much, ma'am, for your support. I'm sure without your support, this wouldn't have been possible to pull off such an event, and we hope to have furthermore fruitful collaborations with you and the esteemed organizations. Next, I would request and call upon our principal, sir, Dr. C.M. Rao, sir, for the valedictory address. Over to you, sir.
As an organizer, I feel 100% satisfied with the inputs that are put by all the faculty members or resource persons, right from first person who is my student and last person, Asha Bajpai madam, who is a senior member of the resource person. So I too share my personal experience, small personal experience, which I faced as a landlord. I want to share with all the August gathering. There is an incident that was happened in my house without my parents present in the house, a POSCO Act. And the particular CW members called me and asked, as the offense is committed in your house, you are liable. Then I asked that particular CWC member, how can I be liable as per the law? Because I am a law professor, I know several things. Only one thing for which the act of others, I am liable only in criminal law, abatement, and also in the agency for contract. But other things in POSCO, whether I am liable or not, I don't know. Whether it was done with my knowledge, without my knowledge, I don't know. I put a girl below some age. If the parents wants to get marry her, the paisa ke liye wo log hamara ghar mein rakha hai because marriage is postponed. And we are very aged parents, around 70, 80 people, 80 aged people are living there. To look after them, she's like a daughter to them. And one day they went to hospital for some reason or the other. In the absence of that particular elder people, some person committed an offense of rape against her, which was not come to our knowledge. So there are occasions where without knowing certain things, we are also responsible not taking care of the servant maid who are in our houses. So if something is, as rightly pointed out in the discussions, if the particular child is below 16 or 18 years, we must also take cognizance of the incident. And we should also be careful about the things that are going in and around us. In case of professional ethics also, we use it to tell to the students, the budding lawyers, you have a social responsibility as a legal fraternity to safeguard the interest of the society where the children are the primary object for target. And on this occasion, I would like to thank all the people who supported us, the participants, the guests, and also our partner, Jean Monnet Module collaborator for us, for a wonderful feast, academic feast for us on this particular International Human Rights Day. Thank you one and all.
Thank you so much, sir, for your ever-present blessings and guidance, and also for this anecdote which you shared. Now for the vote of thanks, I would request our IQAC coordinator and coordinator for this particular event, Dr. Aparna Kotapalle ma'am, to please take over. Over to you, ma'am.
Good afternoon, everyone. Respected principal sir, Dr. Nirmal ma'am, Vajpayee ma'am, and of course Banerjee Chakka sir. It was really a great feast for everyone amongst us, and we have enjoyed it. So let me thank all the speakers of the day for their efforts enriching all of us in the not only theoretical perspectives, but the contemporary challenges that are being faced in the implementation of the law and the processes. Apart from that, for this valedictory session, I am thankful to all the participants for dropping their positive feedback in the chat box. from where we could realize that yes, with whatever intent we had organized this, yes, we have fulfilled the objectives. The participants might have suffered some problem in getting connected for the feedback. We understand because it is online event and your feelings have already reached to us. I am thankful to respected principal sir for giving the valedictory address. Of course, as I have told you in the beginning that it is a GEM model and European Studies Center at JNU who have provided their supportive hand to us with which we could organize this event well. I am thankful to the MLNG societies, all the members, including President sir, Vice President sir, Secretary ma'am, Secretary sir. They all are encouraging all of us for all the academic endeavors. So thankful to all of them. I'm thankful to the teaching and non-teaching staff, support staff of this institute with whose help we could achieve the success. Of course, it is not only the resource persons and our team, it is the outside faculty who had come ahead for introducing the sub-teams. Innovative idea in the mind of our respected as generally it is our own faculty who is involved in the introducing of the sub-teams. But as this time there was no paper presentation as such with the involved faculty, we could make this training program more successful or rather more interactive. And as and when we requested the faculty members from how they readily were available and they introduced the sub-teams. We have taken up this introduction sub-team for the reason that all people who were participating in this event, they were not only from the law background, they were from arts, science, commerce, and even several fields. So, and even a few adults also had joined our hands in this training program. So, I'm thankful to the resource persons, to all those faculty from outside who have introduced the sub-teams. I'm thankful to everyone who has actively participated in this event. And before stopping, I would like to remind you all, please drop your feedback. Feedback link has already been shared. That would certainly, as and when we organize. I expect that all the resource persons available today with us, we will be in touch with them and them be extending their helping hand and cooperation in being thanking you. Thanks for giving me this opportunity to propose vote of thanks. And with the permission of chair, with permission of the guests for the valedictory session, I now declare that this session, this training program is over. Thank you so much. Thank you.
Thank you, Sheetal madam.
Thank you so much, sir. Wish you all the luck for future, sir. Namaskar.
Thank you so much